May I be permitted to mention, my lord, I am paying inclusion of this testamentary episode.
May I have your lordship's kind leave, my lord, to file an
When was
appeal.
the order passed?
Lordship, 1st of August.
May I have Alice and leave to mention, my lord, for inclusion on a contempt application. Contempt.
Non-commercial matter, 1038, item number 5, 5 and 6.
Five and
Oh, 5 seconds. Huh? Local top part.
10:35 before 10.
Item number 61.
61 থেকে 65 টা আগে ডাকো, because ওটা তো just for ascertaining whether parties are.
Item 61 to 65.
Sorry, just.
Mr. Mitra will take it up within 5 minutes.
In fact, my lord, I was wondering, Mr. Jayanto Mitra
Yes. Is item 1,
said that he has item number 1.
but we all
It was utter confusion. But I am here.
Yes, 61 to 65. What is your instruction?
I have taken instruction. In fact, my client is also here.
Yes.
But
Yes or no, Mr. Sen, you don't have to give reasons.
they are
We are not interested. They are not interested. Very well. When will you do the matter?
Not
Monday?
Monday.
Monday, Tuesday, whatever, my lord, is.
Look up your diaries, respective diaries.
I don't have Monday, but your lordship takes commercial matter at the.
Then Wednesday?
I think Wednesday will be better because non-commercial will be first on.
Wednesday.
But this
Wednesday, yeah.
Let it be at the top. My lord, your lordship has already
Yes,
heard.
correct. উপরে রাখবে.
Very well.
Done?
Will be.
আর কি আছে? Yes.
I'm sorry, my lord. I just could not.
Why should you be sorry, Mr. Sen?
No, আমি থাকবো. My learned friend is already asking, should I start if you're not there? I said, no, I'll be here just to finish my submission. I'll be here. Wednesday, my lord.
Item number 5, 6.
medical. But there are 2 appeals. Mr. Mitro's appeal is numbered before mine. I believe. Sorry.
Oh, Mr. Jayanto Mitra is commercial number 1. Commercial number 1.
GCL, I think, my lord, that's.
Yes, your matter.
Yes, yes.
Will this take some time?
This will, my lord, some. Yes.
This will take some time. We would rather than hear the other matter and keep this next week.
No.
Only the last week of August I'm not there. Any other days. Next week is
Oh,
fine.
last week is far away. Yes, next week.
No, it's 8 days away. 8 working days away.
My lord is asking wrong person on my lord working days. He'll tell you how many days to
What
Christmas
is-
vacation.
Don't say working days, say court days. Who knows whether on court days somebody works or not?
Then Monday, if my lord-
Monday.
Monday, I think. Thursday, Wednesday, Tuesday. Monday ওর অসুবিধা আছে। আঠেরো তারিখে
কেন হবে?
Non-commercial. Let it be on the list on Monday.
I'm fine.
Although it's a non-commercial matter, there's very little chance that commercial list will be exhausted. If it is exhausted, this will be taken up. এটা hearing it টপে থাকবে একদম এই দুটো টপে থাকবে
They are in the-
That will not be, my lord. I know, my lord, he is arguing a case against me, my lord, before another division bench.
You're not available when? On?
Monday.
13th and 14th.
14th, I'm not sure.
Monday.
13th.
Monday, I'm
11th.
not.
No,
Monday is
no,
11th.
we are keeping it on 13th.
Oh,
Any day.
13th.
13th.
Yes. Same position. 13th.
Commercial matter. Assignment item number 1.
আমাকে এই ভলিউমটা দাও তো। ভলিউমটা 1, ভলিউম 12।
Well, one request, I don't know whether Mr. Mitra is going to finish today. I don't know, Malad. Malad, if Malad, Mr. Mitra finishes today, Malad will kindly give me Malad the next day, Malad, to reply to Mr. Mitra if he finishes, Malad. Monday or Malad.
It depends কত কিছু প্রপার্টি। হ্যাঁ হ্যাঁ, কত টাকা ছিল, 12.5 কোটি মতো ছিল একটা কন্টিনিউয়াস একটা। Correct, correct. অ্যামাউন্টটা ওই কোন ভলিউমে সার্ভে করতে বলেছিল। Yes, yes, no problem. Let him complete.
Some point, Malad, I'm taking Malad, see Malad, I'll have to leave. That's the only reason, Malad.
Going out of town.
Weekend has Malad
Another jurisdiction.
other duties, what?
Another
Another.
prime jurisdiction.
Friday, well, no, it's a Friday domestic duties he has got to fulfill.
That's the prime jurisdiction.
Prime, yes, that's a prime duty.
Unfortunately, the direct flight, Malad, is very early. That's the difficulty.
When?
Well, it's at 1:50, 1:20.
Oh, then you, yes,
That's
better.
the difficulty, Malad, with that flight.
Yes. All right.
Then the moment he will leave, I shall also sit down.
I'm getting ready. When do I have to answer? Malad, I'm getting ready and then again.
You will put in difficulty, not him, because he'll be flying away his junior.
No, well, I should take some time and I can assure my learned friend. No, no, আমি ঠিক আছে তুমি চাও না তোমার গ্রাউন্ডে আমি অ্যাডজাস্ট নেব
No, no, no.
থ্যাংক ইউ এটাকে এরকম খুলে দিলে কেন মেরে দেবো বলে Well, my submission had been on the last occasion
Yes.
that if the learned tribunal had considered the evidence and had rejected the evidence on the ground that they were immaterial or they are not germane, or my lord, assessing the value of the evidence and rejected it, then my lord, I couldn't have said anything because this was completely within the jurisdiction of the arbitrator. What I am questioning is this, that when a particular issue has fallen for consideration and the tribunal did not consider that particular issue, number one, and because, my lord, it did not consider the issue, therefore, my lord, did not consider the evidence, then, my lord, there is something very seriously wrong. That is my submission. My entire submission is this, my lord. In the instant case, I think that if the learned arbitral tribunal had framed the issues and had considered the issues, then perhaps, my lord, that particular paragraph in the award, impugned award, my lord, that wouldn't have been there. If your lordship, my lord, looks into that particular paragraph of the award. Awardটা কোথায় আছে? ঠিক না, হ্যাঁ, সেটা দাও। আর আমারটা দেখো তো কোথায়? My lord, kindly take the award. That is, my lord, is in the compile, it's a very short compilation that we had given to your lordship, consists containing, my lord, gas sale and purchase agreement and the award, and an order dated 27th September. That's a bunch that we have given to your lordship. At page, my lord, 19 of that. In the award, my lord, para 205. তার মধ্যে আছে, দেখো, এটা মোটা মতো। My lord, para 205. My lord, kindly come to para well, at para 214. This arbitral tribunal has to decide the case of the parties on the basis of the statement of claim and defense. Section 23 of the Arbitration and Conciliation Act provides that the claimant shall state the facts supporting his claim, the points at issue, and relief or remedy sought. And the respondent shall state his defense in respect of these particulars unless the parties have otherwise agreed. My lord, I have shown to your lordship that in my statement of defense, I have dealt with this, my lord, the allegations contained in their claim, and I have said, we have said in that in the statement of defense that, my lord, they did not suffer any loss, and I have given the extensive pleadings on that. Now, what the learned arbitral tribunal did not take note of is the fact that there is an issue which could be raised with regard to the damage suffered. But, well, the paragraph 215, your lordship kindly sees, following the aforesaid legal position, this tribunal has to decide the claim of the claimant on the basis of the pleadings between the parties. The respondent, in course of his argument, sought to urge on the basis of its written note that the claimant had not suffered any loss by way of flaring up. And they have referred to returns filed by the claimant with the Director General of Hydrocarbons, Ministry of Petroleum, Natural Gas. Yes. But in its SOD, the respondent has neither referred to nor disclosed those materials. It is well settled that the facts on which there is no pleading, no evidence can be adduced. Even then, it shows that the chart produced by the respondent that there is flaring up. This tribunal is unable, for the reasons discussed above, to accept the respondent's attempt to contradict the finding of CCI that GECL had to flare up 28.41%. And this, my lord, in my respectful submission, is a grievous error of judgment. In this connection, I shall request your lordship, my lord, keeping this in mind, I shall request your lordship to look into volume, evidence of volume 12. কোথায় আছে? Lordship will please to, I think it will be easier for your lordship if your lordship kindly takes the written notes of submissions which we have filed. Written notes of submissions. It's a thick volume like this. Ache? এটা written notes of submission আমাদের এখানে file না kindly come to the very first page, last paragraph. No loss suffered by the respondent claimant. Read the award of damage is perverse as it ignores material evidence produced with appellant, which in fact established that post termination of the GSPA, the quantum of gas flared by the respondent had remained the same or had reduced, which established that the respondent was able to self-supply the contracted quantity of gas to other parties and had accordingly suffered no loss or damage. The respondent claimant has not given any evidence of any loss suffered on account of termination effected by the appellant by reason of non-consumption of CBM gas to the extent of the minimum guaranteed quantity of the appellant. This is very important because what they have relied upon is, my lord, the quantum of losses, the total quantum of the for up to 2034. What is the total quantum? And my lord, 15% of that. That's all the calculation that has been given. Then, my lord, in paragraph 51 of the AEOE, the affidavit of evidence of CW1 to the effect following effect. I say that CBM gas is not an ordinary article of commerce, and the respondent has to make arrangement for supply of CBM gas to the appellant's factory and works. I say that the respondent does not have readily available market for supply of such minimum quantity of gas of CBM, and as such, the appellant is under an obligation to accept the supply of CBM gas for the minimum quantity for the balance period of the agreement. This is all the evidence that they have been led. Then, my lord, extract from the affidavit of evidence of CW in paragraph 51, book volume. Then, next paragraph. Not only is the evidence from the side of the respondent claimant completely bare and lacking in particulars, the claim is the same is also factually incorrect and has been proved as such as follows. A, the respondent has engaged the service of Care and Crisil for the credit rating of the respondent company, which is generally used by business houses for availing bank loans as well as for boosting the concerned's credentials and for initial public offer (IPO) of shares. Reference may be made to paragraph 86 to 90 of AOE of RW4. Paper book, I have given the volume, relevant extract thereof, annexed here 2 and marked and annexure B. If your lordship, my lord, kindly comes to page 29. Page 29 of this, keeping this. Para 85. The contractual, this is, my lord, the affidavit evidence of RW4. The contractual rate for supply of CBM gas to the respondent was 21 rupees per SCM, which was valid up to May 2015, which included royalty at the rate of 10% and production level payments at the rate of 2.5% payable to the government. For gas which was flared up by the claimant, neither PLP nor royalty is levied and or paid by the claimant to the government. From the reports of Care dated October 2014 and November 2015 and Crisil dated 11 February 2015, it is now clear that the claimants were not in a position to meet the demands of his clients. From these reports, it would be evident that the claimant had entered into commitments far exceeding its production capacity. This was the evidence which was led. Then the respondent had also engaged the service of both Care and Crisil for credit trading for its bank loan purposes. I am fully aware of the system followed by Care and Crisil for rating its clients. In course of my searches on the respective websites, I was able to obtain procedure followed by both Care and Crisil for credit rating of their clients. I have downloaded the procedure from website of Crisil and Care respectively. Copies thereof are there. I have downloaded the said documents from the computer belonging to the respondent situation so and so. Then, my lord, next page, page 30, about 5 lines from the top. I have personally downloaded this printed procedure. What both Care and Crisil do is to send a questionnaire to its client, which has to be filled up by the client, and thereafter, in course of one-to-one meetings with the client has to substantiate such commitments to the concerned credit rating agency. After the credit rating agency is satisfied with the particulars so provided by the client, the same would be taken into consideration by them for preparing their report. One such questionnaire, which the respondent had received in the usual course of from CARE, and one such questionnaire which the respondent had received in the usual course from CRISIL, are tendered in evidence and may be marked Exhibit E so and so respectively. So these were not tendered in evidence and marked exhibit. The reports which the respondent had obtained from CARE and CRISIL on a regular basis have been used by the respondent in connection with the credit facilities available by the respondent from banks and financial institutions. It is because of the goodwill and reputation of CARE and CRISIL that banks and financial institutions, as well as stock exchanges and government agencies, place reliance on them. As far as I am aware, it is mandatory for credit rating agencies to make available to the world at large the reports which they submit to their clients. Similarly, SEBI and stock exchanges make it mandatory to make available to all concerned the reports of the credit rating agencies which are accepted by them. Then, my lord, kindly come to para 92 at page 31. The claimant even otherwise is liable to refund the excess amount realized by it from the respondent beyond the price approved by the Government of India. Alternatively, the respondent states that in course of, this is this is the end. Then, my lord, kindly come to page 32, the extract of the affidavit of evidence of RW2. This your lordship had seen, my lord, RW4, now RW2. There also, again, this evidence has been read. Para 7.1 at page 32. This your lordship will please to find in volume 12, page 1711. So your lordship can mark it, my lord. This is my lord, in volume 12, page 1711. In course of further searches through internet, I was able to obtain reports of rating agencies CARE and CRISIL engaged in the claimant for rating its business. I have downloaded these reports and they have been marked EQER. Then, my lord, CRISIL report is at page 33. Page 33 of these notes. Lordship will please to come to the last paragraph of the trading summary of, my lord, the claimant. GECL's operating income grew 61% CARG over financial year 11 to 13 to 1.6 billion rupees, primarily due to increase in production volume. Then, my lord, given by an increase in the number of producing wells. For financial year 13 as a whole, the EBITDA, my lord, this is, my lord, earning before interest, tax and amortization, margin improved by 64% from 45% in financial year 2011, as increase in revenue absorbed fixed costs. PAT turned positive. PAT is, my lord, profit after tax. Positive for the first time at 358 million rupees on the back of strong growth of EBITDA, despite an increase in depreciation charges and interest cost. ROE, that is return on equity, for the year was low at 12.9%. More than 50% of the wells drilled are in dewatering stage and thus not producing gas. CRISIL research expects ROEs to improve going ahead on the back of increase in the ramp up of production from increasing wells as well as increasing the number of producing wells. My lord, kindly come to page 36 of the same report, CRISIL report. The last, my lord, is a penultimate paragraph on that page. Presence in an industrial belt with high energy demand. GECL's operational Raniganj South Block is situated in the vicinity of Asansol, Raniganj, Durgapur industrial belt. These cities have industrial activity with significant fuel demand, such as steel plants, carbon black, glass and chemical industries. prominent companies in the vicinity include ISCO Steel Plant, Durgapur Steel Plant, Alloy Steel Plant of SAIL, besides Alstom Projects, Graphite India Limited, and Philips Carbon Black. As of March 2013, the company had aggregate commitments to purchase up to 420 SCM of CBM as against 68 SCM, 88 SCM of production in financial year 2013. Then expansion by SAIL to augment demand. That has also been given, stated, your lordship sees, SAIL steel plant in Asansol, Raniganj, Durgapur belt are expanding, which should increase demand for gas in the area as the new units are designed to use a gas as fuel. For instance, SAIL ISCO, a customer of GECL, with a gas offtake of 55 SCM, is one of the biggest steel players in the region and has undertaken an expansion plan of 65 billion to upgrade its sellable steel capacity. Post-expansion, expected to be complete by July, gas requirement is expected to be close to 156 SCM. Similarly, Alloy Steel Plant of SAIL has entered into MOU with Kobe Steel Plant of Japan to set up new unit expected to start by financial year 2016. The expected gas requirement from the unit is 110 SCM. Then lower competition in the region and the fact that gas is cheaper than other substitute fuels. The further thing has been stated here, gas available in Asansol, Raniganj, Durgapur belt is currently low as the development of awarded fields to players such as ONGC, SR Oil and RIL had been slow. Thus, for the past 5 years, GCL's Raniganj block has remained the only commercial producing CBM block catering to this industrial belt. Even the supply of natural gas from other gas producers such as RIL, KG Basin, AP and so, ONGC, so, GSPC, KG Basin, etc., then oil, Assam, etc., is expected to be minimal because these players have minimal surplus gas to sell, and there is no existing pipeline grid network that can serve the Asansol Durgapur region. Well, these were tendered in evidence, and well, cross-examinations were also made. It is not that these were rejected outright at the beginning. I would have thought that if no pleading was there, then my lord, the arbitral, my lord, learned friend's client should have objected to all this evidence going in, firstly. And my lord, the tribunal should have said, no, I am not going to allow to lead this evidence because there is no pleading to support it. That did not happen. So, my lord, I am submitting to your lordship, if this evidence had been considered and rejected, then I would have been out of court. Then I couldn't have said anything. But my lord, not to take note of this on the ground that there is no pleading, well, I couldn't have pleaded crisis and care report and my lord, hydrocarbon report, my lord, in the pleading. That would have been part of the evidence. So, my lord, these are all issues on the question of mitigation of damage. My lord, kindly now come to page 47. This is, my lord, the care report. The well, kindly come to care report, which is at page 47 of this compilation, and this has been also tendered in evidence. And my lord, marked ER something. And my lord, this is for October. This report is October 2014. This care report. And the termination was in July 2014. At page 47 of this, well, I don't know, it is page 515 in printed. 47 perhaps has not come in by way of my lord handwriting. It is there. My lord, kindly mark it because in my copy it is not marked at all. নেই ও তলায় চলে গেছে Well, last paragraph of that credit risk assessment. Kindly come to that. Comfortable financial risk profile led to the higher gas production and sales. That is the title. The financial risk profile of the company has witnessed significant improvement in financial year 2014. The year, my lord, it was terminated. The total income increased by approximately 30% during financial year 14 on account of 25% increase of the volume of gas sold. Then, my lord, 94.38 MMSCM as against 75.75 MMSCM and better sales realization of 20.54 SCM as against 20.85 SCM in financial year 13 refers to the period 1st April to March 31. The realization improved primarily on account of favorable demand-supply scenario. Then PBL TD, that is profit before interest, lease, depreciation, and taxes. Margin witnessed improvement of 500 BPS during financial year 2014 to so and so against 63.98% financial year 2013 on account of increase in operating income absorbing higher capital cost of GECL. PAT, that is profit after tax, turned positive in financial year 13 and has doubled since then. During financial year 14, the company reported a PAT of 77.61 crores, leading to a PAT margin of 38.09 as against PAT of 38.96 crores and PAT margin of so and so during financial year 2013. Then the next sentence is very important. During the first quarter financial year 2015, the company reported a PAT of 23.87 crore on total operating income of 58.05 crore as against PAT of 11.97 crore on total operating income of 41.97 crore during financial year 2014. So 2015, your lordship sees it increase. And our submission had been that it is absurd to think that a person will set up this huge thing for the purpose of supply of gas to a particular party, and that particular party terminates the agreement. And so far as the supplier is concerned, he will dismantle the whole thing and take it away. In fact, my lord, there is no evidence as to what they did with this setup after termination. If they, my lord, there should have been, my lord, something on record to say that we have to dismantle and take away these things. In fact, my lord, they continued to, my lord, retain there. And my lord, that is why there had been an increase in supply. They stopped to one, but they found 3 or 4 other customers to take it. So, my lord, one has to say that this is the loss I have suffered. You cannot just depend upon that, the total quantum of this, what is called? Guaranteed, minimum guaranteed offtake. And then make a percentage of it and say that I have suffered damage. My lord, I respectfully submit to your lordship, my lord, that judgments of the Supreme Court on which reliance had been placed for the purpose of, my lord, arriving at this profit element is, my lord, wrong, my lord. Because those judgments, my lord, go to show a completely different set of facts, which I shall show to your lordship. And then only, my lord, you just cannot say that for 25 years, this is the minimum guaranteed offtake you had promised, you did not take it, and therefore I am entitled to claim 15% of that. Because if you do that, then in the first place you'll have to show that you tried your level, sir.
Actually, my lord, we actually claimed the whole for the entire period which my lord, the contract was to run. That's actually, my lord,
34.
yes,
Till 30.
because that was the minimum guaranteed output. My lord, we claimed for the entire thing.
That's right.
And
This is what I'm questioning.
Then my lord, the learned arbitral tribunal gave us my lord, much less. Since my lord, I already interrupted, I'm so sorry, Mr. Mitra. And another thing is, my lord, there was an order which my lord permitted us my lord, to remove my lord, those equipments my lord, which was supplying to the order my lord, which was also passed. Which supplied to them.
When you first set up your whatever equipment, how does this work? This is natural gas,
Yes, my lord.
right? You have to have a pipeline from your source to their factory.
Yes.
So you had only a pipeline to their factory or other consumers
But
also?
what happened, my lord, there's a main pipeline.
Yes,
My lord, there are other pipelines my lord,
I
which
see.
go off to individual
I see.
branches. So that was lying there for quite some time, and during the pendency of the arbitration, my lord, there was an application made, and then my lord, without prejudice, my lord, it was rejected. Because we had also claimed for specific performance.
No, gas is an important thing. If you miss the flight, do you know what's going to happen?
No, my lord, I am keeping a good watch with my lord, how much. That will be my lord, today, my lord, absolute. I hope, my lord,
Very well.
grateful. I'm grateful for the warning, my lord.
Prior to this, kindly show the chart where after deferred tax, net sales. So it has increased.
My lord, kindly come to page. There is a chart at page 50. কেটে দিয়েছো তুমি পাতাটা 50 page 50. In 2014, Lordship will be pleased to see the net sales are 203.79. This is, I think,
Comparison to 13, sir.
2013. In 2014, we cancelled.
We terminated
No.
July, the month of July.
Well, therefore, in the month of 13 and 14, he was supplying to you.
Yes,
So
but-
this was the problem.
but with an increase of 158 to 2000.
No, so therefore, kindly give me one. Oh, 2013 and 14 যখন তোমার supply করছিল, তখন ওদের supply করছিল। তারপর cancellation এর পর কি
That
হচ্ছে?
year after
সেটা পরে আসছে। So, my lord, in 2014, your lordship will please to see the net sales, my lord, had gone up to the extent, my lord, kindly come to 1, 2, 3, 4, 5, 6, 7. After depreciation, PBT, that is profit before tax. And then next one is PAT, that is profit after tax. And kindly note that 2013, it was 54.79. In 2014, it has gone up 97.29. And the profit after tax from 38.96, it has gone up to 77.61. Well, Lord, kindly turn over the next page, and which is of page 54, not next page, page 54. This scare report continues.
stagnation.
My lord, kindly come to page 54. There's a, this is, my lord, some profit risk assessment. 1, 2, 3, 4, 5, fifth paragraph. Stagnation in financial performance during financial year 15. Kindly see what it says. The total income increased by 12% during financial year 2015 as against financial year 2014. Your lordship has got that. During the year, PBI Ltd of the company increased marginally by 5%. However, PAT witnessed a deterioration on account mark-to-market MTM foreign exchange losses on derivatives transactions. The GCA of the company remained stagnant at 116 crores. The lower than etc. Then, my lord, kindly come to the in that under that heading, my lord, the last but one paragraph. As on September 2015, sales offtake from GECL was approximately 0.10 SCM MD, which is expected to increase to around 0.2 to 0.35 SCM once the sales plant is fully operational by the fourth quarter financial year 16. The company has now signed a minimum guaranteed offtake agreement with SAIL ISP, which provides revenue visibility for medium term. Then technical issues affecting production.
Next is mitigated to larger extent. All the risk is mitigated to larger extent. As written again, there is increase. Expect to increase even further. There is huge.
Then, my lord, kindly come to page 56. Kindly come to page 56. The portion, it is about 4 paragraphs from the top. It is written, traditionally, CBM gas has competitive advantage over other alternative fuels on account of its pricing. However, with falling oil prices globally since last 1 year, the advantage has narrowed down. Going forward, the impact of any further decline in oil prices remains to be seen. However, the risk is mitigated to a large extent as the Asansol-Durgapur belt is a gas deficit region expected to increase even further, and there exists huge requirement of gas by various companies. The prospect is there, the next paragraph. The deficit situation in the domestic natural gas space and competitive advantage of natural gas over conventional fuel augurs well for the company. Going forward, GECL's prospects shall depend on its ability to ramp up its production from already drilled wells and further drilling of wells in the future. And my lord, kindly see, my lord, net sales in the chart, the first one, working result net sales 2013 158.18, 2014 203.79, and 2015 227.33. So again, these are there on record. I am not a technical person, therefore I am not in a position to comment on this. I would have expected, my lord, that the tribunal should have taken note of these things and would have rejected. Then, my lord, I wouldn't have said anything at all. But not taking note of it, completely ignoring the evidence which has been there on record, on the specious ground that there is no pleading, well, I say, my lord, that is something which perhaps was not justified, particularly when it's a claim for damage. So what you are saying is this, that look, by reason of your default, by reason of your wrongful termination of the agreement, I hear the person who was supplying gas to you had suffered this huge loss. I am not in a position to quantify 2034, therefore 15% I am giving. First of all, you must establish that there is loss. And well, when there is a contrary evidence, and this exhaustive evidence was laid in, I showed to your lordship 3-4 volumes of examination chief documents and cross-examination. So, I leave my submission, and there is only other thing apart from crisis and care. There is the hydrocarbon thing. The Director General of Hydrocarbon. Well, this was obtained from RTI. This was also tendered. And this, your lordship will be pleased to find by RWA4. Oh, thank you. My lord, kindly see, my lord, attended by this will appear, my lord, from this. This is exhibit E triple Y, 4 times Y. I don't know what is the quadruple Y.
In our written, we have given
Yes, page 61 to 64.
in page number 5, we have mentioned after cancellation a short brief. How it is relevant with the
Again, first of all, what has been tendered? This, your lordship will be pleased to find in volume 21 of the supplementary affidavit tendered by RW4. Your lordship will be pleased to take this particular volume. 61, আমি জানি, এই তো বুদ্ধি সেটাই বার করছি। My lord, kindly come take page 61 of these notes. এটার এভিডেন্সটা কোথায়? এরা কারা সেটা জানতে চাই। কে এরা?
Rely.
My lord, kindly come back to page 4 of the notes of argument. This is the third evidence which was led. Kindly come to page 4.
Yes, which one? Sorry.
My lord, kindly come to page 4. This is, my lord, in my notes of argument. Page 4, subparagraph D. This is the third evidence which was led. The appellant at the hearing, before the arbitrators produced and relied upon returns, which the respondent herein had filed before the Directorate General of Hydrocarbons regarding gas produced, gas consumed, and gas flared. Reference may be made to exhibit each 4 times Y, paper book, volume 21, pages, numbers so and so to so and so. Relevant extract is annexed hereof and marked annexure F. Now, your lordship will please to come to, first of all, before your lordship comes to my comment, come to page 60. 60 to 61. Page 61. This is pages 61 to 64. Your lordship can make a note of it here in subparagraph D at page 4, page 61. This is an application dated so and so for information under RTI Act. And that way, my lord, we got this information. This is with reference to an application dated 13 July 2017 on the above subject received in this office on so and so. Month-wise details of production, sales, flaring, and internal consumption of gas from Ranigan South Field of GECL as reported by operator to DGH from 2010-2011 to 2014-15 is as under. My lord, kindly see the flaring. Ranigan South, the chart had been given. My lord, date-wise it has been given, flaring and cell dispatch. Kindly turn over the page. My lord, this is April 2010 onwards. And your lordship will please to come to page 64. Kindly come to page 64. This is 2014-15. Your lordship has seen that at page 64. First is April, May, June. June, it was in the month of July, it was terminated. In the June, well, the flaring up was.
What is the unit, Mr. Mitro? This 1.584, 11.227, what?
Well, lordship is looking into
SCM.
Unit of gas.
Well, this is a measurement of the gas by way of unit.
Correct. Yes. No, why we are asking, as my brother rightly points out, there's some amount of flaring that's indicated by this also. Unless the percentage is mentioned, we will not know
how much is flared and how much is there.
They claim 28.45 or something like that.
Well, I am just looking at the figure. I tell you, lordship, very frankly, I am also not an expert on this, but I kindly come to page 64. In the month of June 14, that means 1 month before the.
We have made a percentage in our check.
No. Well, kindly come to page 64. June 14, it was the flaring up was 0.671 That is before the termination. Then, my lord, kindly see, come to the
June.
thereafter,
332.
my lord, it has gone down until ultimately
671 cannot be 20.
in January 15, it is more. Then it went down again
Generally,
0.321.
can't be 28%. Total back 132, which is 7. Over near to 28. 7% is gone. 100 production hole 7%. 132. You will be able to get an idea. If you take the total production figure,
Yes, ma'am.
whatever the unit be, and the flaring
Yes.
figure, you can make an idea of the percentage roughly. For example, 2014-15 at page 64, if you come to 64,
Yes, ma'am.
2015 total, if you see at the bottom,
Yes.
2020, 14-15 total.
Yes.
Total production was 132. Let's say 130.
Correct. Yes.
And flaring was 7.
That's right.
So 7 out of 132 was flared, which is roughly about 5% or less.
It comes to 3. We have made a summary of it.
3 point something.
Yes. Your lordship kindly comes to page 5 of my notes of argument. On the basis of this, we have made a summary.
Oh, I see. তাহলে তো খাটলাম কেন?
Well, kindly see, after cancellation of the agreement, your lordship sees, my lord, page 64, this first, my lord, this chart is given. July 14 to December 14. The flaring is 3.12%. Then, my lord, page 61, the corresponding 6 months from July 13 to, my lord, to December 13, 14.69. And before cancellation of the agreement, January 14 to June 13, 6.51. So, my lord, the flaring in the month of July 2014 to December 2014 has considerably gone down, 3.12%. On the basis of this calculation has been made, I am not very sure whether the calculation is correct or not. But then again, my lord, I am showing that the flaring up was less. Now, I only put it this way, that whether this is right or wrong, this is something, an assessment of evidence, to which I have got nothing to say. If, my lord, sorry.
All you say is that it needed to be considered.
Needed to
Whether accepted or rejected is different.
That is for the arbitrators, my lord. And as I say, my lord, to be very frank, on the basis of the judgments which have been delivered, if the arbitrators have considered this and rejected it, then I would have been out of court. This is, my lord, assessment of evidence, which is within the sole jurisdiction of the arbitral tribunal. Well, my issue is the entire submission that I am making before lordship is non-consideration of material evidence. This is a vital aspect, my lord, in an arbitration proceedings. My lord, in a trial court, if a suit is heard,
Mr. Smith, 1 minute. 1 minute.
yes, sir.
Meters to PGI works. On the basis of that, the chart was there. Started up 4.
আমাদের কালকে শিলং থেকে গুয়াহাটি 4 ঘন্টা লেগেছে। কোন রকমের কাজটা ক্লেম হয়েছে। আমি 7:50 ফ্লাইট ছিল, আমি গিয়ে পৌঁছেছি 7:15। ওরা টেলিফোন করে বলে দিয়েছে যে মিস্টার মিত্র ইজ কামিং, ওদিকে হুইল চেয়ার নিয়ে দাঁড়িয়ে আছে হোটেলে। হুইল চেয়ার কি হবে? নো স্যার, আই উইল টেক ইউ as fast as I can. No, 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 I'm not going to leave. এই জন্য একটু দাঁড়ানো ভালো হবে। বলছি রে বাবা, করে গেছে। Well, kindly in this connection, come back to subparagraph D at page 4. This is of vital importance. Well, this summary that I had just now given to your lordship is based upon their evidence, not my evidence. Kindly see, my lord, subparagraph D. The appellant had at the hearing before the arbitrators produced and relied on returns which the respondent herein, that is the claimant, had filed before the Directorate of General Hydrocarbon regarding gas produced, gas consumed, gas flared. And these exhibits are on the basis of what they produced before the director. So I relied upon their evidence, rather their documents, on the basis of which, my lord, this Directorate of General Hydrocarbon had made its report. And that report I relied upon. I said that this is the, if you see that, you will find that lesser amount of gas has been flared after the termination. This has not been taken note of. And this is my lord, my basic grievance insofar as the award is concerned. Now, my lord, keeping this in mind, my lord, what is it that I am submitting? I am submitting this, that there should not have been a blanket order awarding damage. Why? Because if the quantum of flaring up subsequent to the termination had been taken note of, then the arbitrators themselves would have found that lesser gas has been flared up. So definitely, my lord, the more gas had been sold. I was not there in the picture. The gas lines were laid out. What had they been doing? Did they dismantle it? There was a direction for dismantling, or rather liberty to dismantle. What is the evidence that they did? If they dismantle, then how could they have, the Directorate of Hydrocarbon, on the basis of their record, could have filed this report? I mean, I am perplexed. What is the answer to that? There should have been an answer. And this is, my lord, this would have gone in the matter of mitigation of damage. Now, if it is found ultimately, by way of evidence, that the person who is claiming damage in actual fact did not suffer any damage, then what happens? Could the arbitrators have awarded damage? And this is the short issue.
This goes to the root of the principle. Why damage?
Yes.
Why does one award damage? Is it penal for breach of contract, or is it compensatory?
It can't be penal because of Section 74.
It's compensatory.
It's compensatory. That is why the Section 74 says that that is the ceiling. But you will have to prove damage. If you prove damage, then the maximum damage you can claim is what had been contemplated in the
As Cheshire defines it, damage is awarded to put the person who has suffered breach in a position as if breach had not
had been. My
happened.
lord, this is exactly the principle, and mitigation is a part of it. My lord, I just indicate to your lordship, my lord, now, on the basis of this evidence was there. I am not going to take your lordship into the cross-examination. It is quite possible that my witnesses were, my lord, shaken in cross-examination. It is quite possible that my witnesses were disbelieved, should have been disbelieved in cross-examination. This is a completely separate aspect of the matter. I say that, did you or did you not consider that? If you did not consider that, there had been a perversity in the award. I am putting my case like that. এটা করবে। $219. Yeah. এটা তোমার ভার্সন। question লাগছে। My lord, my learned junior Mr. Sen rightly points out this is something, my lord, I have made a note of it, but I ignored it. Kindly, my lord, come to their witness. This question was put to their witness. It is not that something I suddenly slapped before the arbitrators. No, this is there. Kindly, my lord, come to page 83 of the notes. I have extracted from the cross-examination. It is 82. Kindly come to page 82. Extract from the cross-examination of CW1. Extract from the cross-examination of CW1, page 82. পড়া যাচ্ছে না। দেখে নিয়ে দেখো। Your Lordship, can you come to page 83 now? Question 219. Why does the claimant, according to you, continuously strive to increase the production of CBM gas? Is it because the demand for supply of CBM gas has been increasing continuously? The answer is the claimant needs to adhere to the commitment that it made to the government as well as contracted customers. Can you note this? The claimant needs to adhere to the commitments that it made to the government as well as contracted customers. 220. How many customers does the claimant have with minimum guaranteed offtake commitments? I need to check. Then 221. Has there been any unusual increase or decrease in flaring of gas by the claimant in any time in 2014? Answer is there has been flaring gas in 2014. I am not aware of the exact quantum of flaring. Then 222. As a senior officer of the claimant, would you not have been aware had there been any unusual increase or decrease in the flaring of CBM gas at any time during the year 2014? Flaring numbers are reported by separate departments which in no way related to marketing that I am concerned in the department. So, my lord, the witness had been cross-examined also. These were shown to him with regard to the flaring of the gas. And this is the crux of the matter. On the basis of 28.47% of flaring, the damage has been awarded. My lord, is it, my lord, can I not submit to your lordship that there on the as against the evidence which has been led by the respondent, the quantum of evidence in contradiction, so far as the claimant is concerned, is minimal. Then again, my lord, kindly come to page 85. Kindly come to page 85. My lord, kindly come to page 84. I think, my lord, I should take it to your lordship from this. 219. Why does the claimant, according to you, continuously strive to increase the production of CBM gas? Is it because demand and supply? Answer is, I have shown to your lordship, it made to the government as well as contracted customers. Then, my lord, he said, I do not know. Kindly, my lord, come to page 85 now. 225. Was the flaring of CBM gas at any point of time during the year 2014 more than that of the corresponding period in the year 2013? I am not aware of the quantum of flaring in 2013 as well as 2014. But there was flaring in 2013 also to some extent, and there was flaring in the year 2014. If I put it to you that flaring of CBM gas during 2014 was never in excess of the flaring of CBM gas during the year 2013 by the claimant, would you be able to dispute that? I have already mentioned that I am not aware of the flaring data, thus neither confirm nor dispute. আবার কি আছে 86 এটা 344 345 then my lord at question 334 344 my lord, this Mr. Mitra is my lord, Mr. Abhijit Mitra who processed this. Question 344 at page 86. Is the claimant required to file periodically returns with the Directorate General of Hydrocarbon giving particulars of production, sales and flaring of CBM gas at its wellhead at Ranigan? There are many reporting to Directorate General of Hydrocarbons by the concerned department of the claimant. If I told you that as per the claimant's reporting to the Directorate of General Hydrocarbon, the total gas flared up at the Raniganj wellhead during the month of June 2014 was 0.67 mmCPM SCM, what would be your answer? There was flaring in the month of June 2014. I am not aware of the quantum of gas. In fact, my lord, they were not aware of this. Then, my lord, kindly see, I suggest to you 0.20 SCM was the total gas flared up in Raniganj wellhead of the claimant in July 2014, as per the claimant's reporting to the Director General of Hydrocarbon. Do you agree? As mentioned above, I am not aware. I suggest to you that at its Raniganj wellhead, the claimant had flared up 2.62 SCM of CBM gas in the month of July 2013, as per the claimant's reporting to the Director General of Hydrocarbon. Do you agree? As mentioned above, I am not aware. I suggest to you that the claimant flared up 1.34 SCM CBM gas at its Raniganj wellhead during the month of April 2014, as per the claimant's reporting to the Director General of Hydrocarbon. As mentioned above, I am not aware. So, my lord, suggestions were being made on the basis of the Director of Hydrocarbon's report. And my lord, he was not in a position to. So, my lord, here, so, my lord, this 28.47% bogey, which was put up before the learned judge, had no evidentiary value because this is a contention of the parties I have shown to your lordship. I don't want to repeat myself. And my lord, this was the only thin thread on the basis of which the entire finding of the tribunal, I say that without any fear of contradiction, my lord, the entire decision of the learned arbitral tribunal was hinged. This 28.47% is a statement made by the claimant before a particular authority, which was taken as the gospel truth because it was held to be a sort of finding of the CCI, which is not correct. This was the tribunal says, and the learned trial judge also said that this was confirmed by the Delhi High Court. I say that Delhi High Court, there's not a whisper of flaring of gas, not a whisper in the whole thing. Because naturally, what was the subject matter of dispute before them? It is only completely confined to the Competition Act, nothing else, nothing more, nothing less. So it went into the Competition Act. Question of flaring was not at all German. and it was not even considered. The recording of the submission had become, my lord, the foundation of the entire finding of the learned tribunal. And the learned trial judge, my lord, also unfortunately was misled into believing that that is a finding. And against this, my lord, on the face of on the teeth of this evidence, which was not considered at all. My lord, keeping this in mind, my lord, if I may respectfully cite before your lordship a few judgments on this. First of all, my lord, I will draw your lordship's attention again to the Indian Contract Act, section 73, 74. These are all judgments on this. Nothing, there is nothing else, my lord, is there.
এটা সরব কি চাই
My lord, kindly take 73. I have already placed before lordship just for the purpose of my lord, as an by way of introduction to my further submission, my lord, I am just relying upon these two. Section 73 is compensation for loss or damage caused by breach of contract. When a contract has been broken, the party who suffers by such breach is entitled to receive from the party who has broken the contract compensation for any loss or damage caused to him thereby, which naturally arose in the usual course of things from such breach, or which the parties knew when they made the contract to be likely to result from the breach of it. My lord, is a very written in a very felicitous language, and my lord, this summarizes the entire law of damage. When the contract has been broken, the party who suffers by such breach. So first is the party who suffers by such breach. Therefore, my lord, the party concerned will have to suffer. Yes. If he does not suffer, then he is not entitled to claim any damage. First, from the party who has broken the contract, compensation for any loss. So, my lord, suffers by such breach by way of compensation for any loss or damage caused to him thereby. So he has to suffer, my lord, loss or damage. If he cannot prove suffering of loss and damage, then on the basis of a formula, you cannot claim the percentage, which naturally arose in the usual course of things from such breach. Each word is important, which naturally arose in the usual course of things. Something will not naturally arise in the usual course of things if you are selling the same gas to somebody else, or which the parties knew when they made the contract to be likely to result from the breach of it. Such compensation is not to be given for any remote or indirect loss or damage sustained by reason of such breach. I am not troubling your lordship with this. Then,
You may recall this is codification of the principle laid down by the very old case of Hadley and Baxendale.
correct, absolutely correct. Hadley and Baxendale. This principle has been really, my lord, kindly note 1872 Act. Nobody could touch it since then. Nobody could touch it. As against, my lord, the acts which have been subsequently, my lord, and after 1947, see the number of amendments that have come in, including Arbitration and Conciliation Act. My lord, large-scale amendments have come in. What about our Constitution of India? 101 amendments. This is, my lord, the result of long experience. And, my lord, explanation, which, my lord, your lordship was pleased to point out, in estimating the loss or damage arising from a breach of contract, the means which existed of remedying the inconvenience caused by the non-performance of the contract must be taken into account. Must be taken into account. If you do not take into account, you commit a violation of the law of the land. We come under section 34. This is a violation of the law of the land. In estimating the loss or damage arising from the breach of contract, the means which existed of remedying the inconvenience caused by the non-performance of the contract must be taken into account. And there, my lord, there are 20 different explanations here. I have to try and find out if any of the explanations, my lord, come to my aid.
Illustrations.
Yes. My lord, then section 74. Compensation for breach of contract where penalty is stipulated for. When a contract has been broken, if a sum is named in the contract as the amount to be paid, in our case also the same. In case of such breach, or if the contract contains any other stipulation by way of penalty, the party complaining of the breach is entitled, whether or not actual damage or loss is proved to have been caused thereby, to receive from the party who has broken the contract reasonable compensation not exceeding the amount named, or as the case may be, the penalty stipulated for. Therefore, if, my lord, there is a contract in which an amount has been specified to be payable in case of breach, the party complaining of the breach is entitled, whether or not actual damage or loss is proved to have been caused thereby. The thing is this has been interpreted to mean that you will have to prove that you have suffered loss and damage. You do not have to prove that what is the actual loss. Once you prove that you have suffered loss or damage, then, my lord, the ceiling is that what has been mentioned. So that amount will be paid to you. But if it is proved that no, you did not suffer that amount of loss or damage, but you suffered loss or damage something less, then the less amount will be paid. But the point is this, you have to show that you have suffered loss and damage. That is section 73. 73 and 74 are to be read together.
Genuine pre-estimate by the parties.
Right. Genuine pre-estimate by the party. My lord, if my learned friend's client had been able to prove that they did not sell it at all to the outsiders, they had to dismantle the whole thing and carried the machinery altogether, then perhaps some case could have been made out. But, my lord, what has been shown here is that they went on, my lord, supplying the gas because they had customers. I don't blame them. They're businessmen. I mean, they are not, my lord, sitting over there for the purpose of assessment of damage by a court of law. So by businessmen, they had sold it. I don't complain of that. But what I say is that if you have done that, then you must give me credit for all that. If you do not do so, you are not discharging your duty of mitigation. And this is where, my lord, the default has been committed on their part. My lord, on this aspect of the matter, if I may just show your lordship, my lord, the judgment of the English court, which has been followed in, my lord, by our court. Well, this is Mr. Mukherjee. Mr. S.N. Mukherjee, my lord, saw me handling these things, and he said, I shall sit with you and I shall teach you how to use the liquid test. I said, perhaps not in this life, perhaps I will be able to learn what you have done. He said that you have to handle all these things. This is too much. My lord, this is, my lord, House of Lords judgment of British Westinghouse Electric Manufacturing Company and versus Underground Electric Railways Company of London. আমি একটা কপি দেবো, একটা কপি দিয়ে দাও ওদের, কারণ কপি পাওয়া মুশকিল। Well, I will take your lordship straight to the judgment of Viscount Holden, Lord Chancellor. If your lordship comes to page 682. Viscount Holden, Lord Chancellor's judgment, the question raised in this appeal relates to the measure of damage payable by the appellants to the respondent on account of breach of contract by the appellant. That is the issue. Then your lordship will please to come straight away. So I am not troubling your lordship with the various discussions which had taken place. Kindly come to page 688. Copy দিয়েছি তো? হ্যাঁ, ঠিক আছে। 688, the last paragraph on that page. In order to come to a conclusion on the question as to damages thus raised, it is essential to bear in mind certain propositions which I think are well established. In some of the cases, there are expressions as to the principles governing the measure of general damages, which at first sight seem difficult to harmonize. The apparent discrepancies are, however, mainly due to the varying nature of the particular question submitted for decision. The quantum of damages is a question of fact, and the only guidance the law can give is to lay down general principles which afford at times but scanty assistance in dealing with the particular case. Therefore, it's basically a question of fact. And this fact had not been, my lord, considered by the tribunal in our case. The judges who give guidance to juries in these cases have necessarily to look at the special character and to mold for the purpose of different kinds of claim the expression of the general principles which apply to them. And this is apt to give rise to appearance of ambiguity. Subject to these observations, I think, there are certain broad principles which are quite well settled. The first is that, as far as possible, he who has proved a breach of a bargain to supply what he contracted to get is to be placed, as far as money can do it, in as good a situation as if the contract had been performed. This is what had fallen from your lordship just now. The fundamental basis is thus compensation for pecuniary loss naturally flowing from the breach. But this first principle is qualified by a second, which imposes on the plaintiff, kindly note these words, which imposes on a plaintiff the duty of taking all reasonable steps to mitigate the loss consequent on the breach and debars him from claiming any part of the damage which is due to his neglected to take such steps. Loud and clear. In the words of Lord Justice James in Dunkirk Colliery versus Liver, then quote, the person who has broken the contract is not to be exposed to additional cost by reason of the plaintiffs not doing what they ought to have done as reasonable men, and the plaintiffs not being under any obligation to do anything otherwise than in the ordinary course of business. As Lord Justice James indicates, this principle does not impose on the plaintiff an obligation to take any step which a reasonable or prudent man would not ordinarily take in the course of business. But when in the course of his business he has taken action arising out of the transaction, which action has diminished his loss, the effect in actual diminution of the loss he has suffered may be taken into account even though there was no duty on him to act. So, my lord, very felicitously it has been put. The law.
But any additional cost incurred for doing that?
You don't have to. You don't have to go out of your way to do something which is not required under the law for you to do. Then, my lord, kindly, I am not troubling your lordship with Staniforth versus Lyle. Next paragraph in New Zealand judgment. Kindly, my lord, turn over the page 690. What the Court of Common Pleas decided in the second sentence of that page. the Court of Common Pleas decided that the action was to be viewed as one for a breach of contract to put the cargo on board the plaintiff's vessels, for which the plaintiff was entitled to recover all the damages he has incurred, but that he was bound to bring into account in ascertaining the damage arising from the breach, the advantages which had accrued to him because of the course he had chosen to adopt. So, my lord, that is the basis for, my lord, ascertaining the quantum of damage. The only other paragraph, page 691. Page 61, last paragraph. No, not the last, but one paragraph. I think the principle which applies here is that which makes it right for the jury or arbitrator to look at what actually happened and to balance the loss and gain. What actually happened and to balance the loss and gain. The transaction was not res inter alios acta, but one in which the person whose contract was broken took a reasonable and prudent course, quite naturally arising out of the circumstances in which he was placed by the breach. Then, my lord, kindly turn over the page 692, the last paragraph. For the reasons I have given, I think that the question of law stated by the arbitrator in the special case have been wrongly answered by the courts below. The result is that the award cannot stand and must be sent back to the arbitrator with a declaration that the contention of the appellant on the first question so far, but only so far, as they contended that the several facts relied upon by them were relevant matters to be considered by the arbitrator in assessing the damage, was right, and that the respondents on the second question was wrong. So, my lord, this is in arbitration proceedings this happened. And, my lord, the basic issue had not been taken note of by the arbitrators. So the matter was sent back.
We'll give you a break for 5 minutes.
My lord, I am grateful to your lordship. I need it. Well, the next judgment I shall cite before Lordship is another English judgment before I go to India, come back to India. This is well, the appeal court judgment reported in 1919 to King's Bench, page 581. 1919 to King's Bench, page 581. Okay, copy the this. My lord, the question which arose in this will be pleased to your lordship will be pleased to find in the judgment of Mrs. McCurdy, which was, my lord, the trial court judgment at page 585. তোমার ইয়েটা কোথায় গেল, কলমটা কোথায় গেল? না না, এটা দিও না, হারিয়ে ফেল। এই যে আছে। Page 585, second paragraph. Now, a serious question of law arises on the question of damages. I find as a fact that the defendant was ready and willing to supply the goods to the plaintiffs at times and prices specified in the contract, provided the plaintiffs paid cash on delivery. Mr. Matthews argued with characteristic vigor and ability that the plaintiffs were entitled to ignore that offer on the ground that a person who has repudiated a contract cannot place the other party to the contract under an obligation to diminish his loss by accepting a new offer made by the party in default. The question is of juristic importance. What is the rule of law as to the duty to mitigate damages? This is the question. I'm not troubling your lordship with the trial court judgment anymore. The defendant made an offer which was not accepted. So, my lord, the matter came up before the Court of Appeal on that issue.
After initially being in breach, then the defendant made
Then
an
the
offer which was not
defendant
accepted.
That was rejected. See, my lord, how the appeal court has dealt with this. Kindly come to page 588. This Lord Justice Banks judgment at page 588. In these circumstances, the only question is whether the appellants can establish that as a matter of law, they were not bound to consider any offer made by the respondent because of the attitude she had taken up. Then, my lord, kindly ignore, my lord, this Westinghouse, which I just now placed before lordship. After that, my lord, after the quotation, Dunkirk, Colliery and Lever is there, and thereafter. It is plain that the question what is reasonable for a person to do in mitigation of his damages cannot be a question of law, but must be one of fact in the circumstances of each particular case. Then, my lord, I take your lordship to the judgment of Lord Justice Scruton, which is of importance. Short paragraph at page 589. Lord Justice Scruton said that I am of the same opinion. Whether it would be more correct to say that a plaintiff must minimize his damages or to say that he can recover no more than he would have suffered if he had acted reasonably, because any further damages do not reasonably follow from the defendant's breach. The result is the same. The plaintiff must take all reasonable steps to mitigate the loss consequent on the breach, and this principle debars him from claiming any part of the damage which is due to his neglect to take such steps. British Westinghouse has been quoted. Then Mr. Matthews has contended that in considering what steps should be taken to mitigate the damage, all contractual relations with the party in default must be excluded. That is contrary to my experience. In certain cases of personal service, it may be unreasonable to expect a plaintiff to consider an offer from the other party who has grossly injured him. But in commercial contracts, it is generally reasonable to accept an offer from the party in default. However, it is always a question of fact. So, my lord, here, as the facts are slightly.
How beautifully put.
How beautifully put. One small sentences. And my lord, kindly see how felicitous the language is. Mr. Matthews has contended that considering what steps should be taken to mitigate the damage, all contractual relations with the party in default must be excluded. Answering, that is contrary to my experience. Nothing more. No criticism. My lord, this is the next judgment. My lord, third judgment is, my lord, I am going to cite before lordship is an Indian judgment. Judgment, my lord, the Indian court. This is reported in, my lord, 1984 Supreme Court cases, page 636. This is a judgment of Mrs. Tulzapurkar and Mrs. Pathak.
Hmm.
1984 Supreme Court cases 636. With copy language. My lord, kindly come straight to paragraph 13 at page 644. There is a lot of facts involved in this. I'm not going to trouble your lordship. Paragraph 13 at page 644. The last contention urged by the counsel for the appellants on the quantum of loss claimed by the respondent comprised a two-pronged attack against the resale held in respect of the defaulted lots of coffee. First, the board was under an obligation to mitigate or minimize the loss arising from the failure on the part of the appellants to pay for and take delivery of the coffee allotted to him at the pool auction. But instead, deliberate measures were taken by the board to bring down the prices of coffee, and it then effected a resale on December 23, 1952, resulting in the alleged loss of rupees 34,570 and rupees 5,917, respectively, which could not be regarded at that time. Perhaps now this 34,570 will become 34 lakhs 5.
Nobody would go to Supreme Court for that amount.
Yes, quite right. But that amount had the value, which could not be regarded as a loss directly and naturally arising from the breach of the ordinary course of events, but was unreal, created and brought about by the respondent, and therefore the same was not recoverable from the appellants. Secondly, the resale was not held within reasonable time of breach, but was inordinately delayed, and therefore the appellants were not liable to the quantum claimed. It may be stated that the contention that the defaulted coffee ought to have been put up for sale at export auction and not at pool auction, though urged in the lower courts, was not pressed before us. For the reasons which we shall indicate presently, we do not find substance in either of these two grounds of attack. At the outset, it must be observed, the principle of mitigation of loss does not give any right to the party who is in breach of the contract, but it is a concept that has to be borne in mind by the court while awarding damages. The respondent did not have any right to claim mitigation, but my lord, the court will have to remember while awarding damages. The correct statement of law in this behalf is found in the HON'BLE's Laws of England, volume 12, para 1193. Plaintiff's duty to mitigate loss. The plaintiff must take all reasonable steps to mitigate the loss. The onus is wholly on the plaintiff, which he has sustained consequent upon the defendant's wrong. And if he fails to do so, he cannot claim damages for any loss which he ought reasonably to have avoided. I mean, very pithily put, and this is the correct law. Plaintiff must take all reasonable steps to mitigate the loss, which he has sustained consequent upon the defendant's wrong. And if he fails to do so, he cannot claim damages for any such loss which he ought reasonably to have avoided. My lord, this is a very important principle in the light of the submission generally we make in a court of law, that there is a pre-estimate of damage contained in this. There is a breach of contract. Therefore, you award me damage. What is the damage? The total quantum of the transaction, and then, my lord, 15%. And then this is not so easy as all that. Supreme Court presently, my lord, has become conscious of it, And my lord, in awarding damages, the court says that one will have to prove damage that he has suffered. For example, my lord, the examples have been given. If there is a wrongful termination of the contract of construction contract, wrongful termination, damage is claimed. The courts are now asking that after this wrongful termination, what work did you get? What work did you do? Because you became free from that particular contract. So then you are free to go elsewhere for the purpose of doing any other work. Did you do that? If you did not do that, then you cannot just sit in your house. No, don't undertake any work whatsoever, and then come to the court and claim 15% of the amount of the total amount of price, the value that was to be granted under the earlier contract. Because in the meantime, what have you done? You are free now. So here, my lord, this is the onus is upon the plaintiff. The plaintiff must take all reasonable steps to mitigate the loss, which he has sustained consequent upon the defendant's wrong. And if he fails to do so, he cannot claim damages for any such loss which he ought reasonably to have avoided. Again, in para 1194 at page 478, the following statement occurs under the heading standard of conduct required of the plaintiff. Standard of conduct required of the plaintiff. The plaintiff is only required to act reasonably, and whether he has done so is a question of fact in the circumstances of each particular case, and not a question of law. He must act not only in his own interest, but also in the interest of the defendant, and keep down the damages so far as is reasonable and proper by acting reasonably in the matter. In cases of breach of contract, the plaintiff is under no obligation to do anything other than in ordinary course of business. And where he has been placed in a position of embarrassment, the measure which he may be driven to adopt in order to extricate himself ought not to be weighed in nice scales at the instance of the defendant whose breach of contract has occasioned the difficulty. That means he doesn't have to go out of the way to be too polite to the other side. Then the plaintiff is under no obligation to destroy his own property or to injure himself or his commercial reputation to reduce the damages payable by the defendant. Furthermore, the plaintiff need not take steps which would injure innocent person. Then, my lord, the different English judgments have been referred to. Lord Shankey, Lord Chancellor's judgment. Then, my lord, James Findlay's judgment. Then it says the court in England, the law is that a person is not obliged to minimize the damage on behalf of another who has broken a contract if by doing so he would have injured his commercial reputation by getting a bad name in the trade. This is the restriction. This is the limitation, that he doesn't have to go out of the way to injure his own reputation, commercial reputation. Then para 33. In American Jurisprudence, Volume 2, Second edition, volume 22, para 33, has been quoted. The general doctrine of avoidable consequences applies to the measure of damage in action for contract. Thus, damages awarded to the non-defaulting party to a contract will be determined and measured as though that party had made reasonable efforts to avoid the losses resulting from the default. Some courts have stated this doctrine in terms of a duty owing to the innocent party to the one in default. That is, that the person who is seeking damages for breach of contract has a duty to minimize those damages. However, on analysis, it is clear that in contract cases, as well as generally, there is no duty to minimize the damage, because no one has a right of action against the non-defaulting party if he does not reasonably avoid certain consequences arising from the default. Such a failure does not make the non-defaulting party liable to suits. It only indicates that the damages actually suffered are greater than the law will compensate. So it only indicates that the damages actually suffered are greater than the law will compensate. Therefore, in contract actions, the doctrine of avoidable consequence is only a statement about how damages will be measured.
Yes.
So, my lord, this is very succinctly put. What it says is this: in contract actions, no duty can be imposed upon the plaintiff that he has got a duty to mitigate. So, it will not provide a cause of action for the defendant to file a suit for the purpose of claiming mitigation. But what he says is, in contract actions, the doctrine of avoidable consequences is only a statement about how damages will be measured. So, for the purpose of measurement of damage only,
So if you don't discharge your duty to mitigate, you do it at your own peril because the quantum of damages may go down.
this is what it is. Well, really, these are the judgments which I wanted to cite before your lordship on the mitigation of damage issue. Now, my lord, we come to the question of how the damages are to be. Your lordship, my lord, has seen the treaty on contract. My lord, if I may just indicate to your lordship the paragraphs. Treaty on contract, আমি তোমাদের copy দিয়েছি। তাই তো? Copy দিয়েছি। My lord, on mitigation of damage, my lord, I just wind up my submission on mitigation of damage issue on this, by this. My lord, kindly take your lordship has got a copy of that treaty on contract. The rules have been very nicely put here, so my lord, I could not resist the temptation of citing it before your lordship regarding mitigation. There are 3 rules often referred to under comprehensive heading of mitigation. They will be considered in turn. First, the plaintiff cannot recover for loss consequent upon the defendant's breach of contract where the plaintiff could have avoided the loss by taking reasonable steps. That's the first issue. Second is, if the plaintiff in fact avoids or mitigates his loss consequent upon the defendant's breach, he cannot recover for such avoided loss, even though the steps he took were more than could be reasonably required of him under the rule. Thirdly, where the plaintiff incurs loss or expense, taking reasonable steps to mitigate the loss resulting from the defendant's breach, the plaintiff may recover this further loss or expenses from the defendant. So if he goes out of the way and do something more, then he will be entitled to recover that. Then avoidable loss. The first rule imposes on the plaintiff the duty. Well, this is what I am on. It imposes on the plaintiff a duty of taking all reasonable steps to mitigate the loss consequent on the breach and debars him from claiming any part of the damage which is due to his neglect to take such steps. Well, at this, your lordship will please to see
British Westinghouse. Yes.
British Westinghouse. The position of the plaintiff under this rule is similar to that of the plaintiff whose damage are reduced because of his contributory negligence. The onus of proof is on the defendant, who must show that the plaintiff ought, as a reasonable person, to have taken certain steps to mitigate his loss. This is what I have done. And this is what has not been taken note of. Any loss which is directly caused by a failure to fulfill his duty is not recoverable from the defendant. Thus, an employee who has been wrongfully dismissed and unreasonably refuses to accept another equally, kindly note this, and unreasonably refuses to accept another equally remunerative post to date from the dismissal is only entitled to nominal damages. So, my lord, if this is what the example I gave. If the defendant has wrongfully committed breach of the contract, you put an end to the contract. But that's not the end of the matter. The amount of damage that we will claim is something which you would have suffered in the usual, reasonably in the usual course of things. Now, if you do not take the reasonable steps for the purpose of mitigating this damage, then you cannot claim the damage. This is exactly what has been said. The plaintiff is not under an obligation to do anything other than the ordinary course of business. The standard is not high one, since the defendant is the wrongdoer. The law is satisfied if the party placed in difficult situation by reason of the breach of duty owed to him has acted reasonably in the adoption of remedial measures and he will not be held disentitled to recover the cost of such measures merely because the party in breach can suggest that other measures were less burdensome to him might have taken. The plaintiff has reasonable time after the breach, the length depending upon on all circumstances before his duty to mitigate arises. Questions about reasonableness of the plaintiff's steps to mitigate his loss have arisen in cases discussed elsewhere, where the defendant has failed to complete the contractual work, building or repair work, and the plaintiff claims damage for the cost of substituted performance by a third party. That's one of the risk purchase. Then the plaintiff is under no duty to take risk with his money in attempting to mitigate, not to take a step which might endanger his own commercial reputation by enforcing subcontracts. The plaintiff is under no duty, even under an indemnity, to embark on a complicated and difficult piece of litigation against the third party, nor is the plaintiff required to sacrifice any of the property or rights in order to mitigate the loss. It has been suggested that the plaintiff's duty to mitigate does not require him to guard against the effects of inflation per se. That is, it does not apply to the risk of pure price increase, which may lead to inflationary increase in damages after the date of the breach of the contract. My lord, this paragraph has been written, my lord, on the basis of the decided cases. My lord, these cases are there. Then sale of goods. Kindly, my lord, come to say this, 1717. In contract for the sale of goods, the normal rule of measure of damage assumes that the innocent party would act immediately upon the breach and buy or sell in the market, if there was an available market. Where the plaintiff does not accept the defendant's anticipatory breach of contract, there is no duty of the plaintiff to mitigate his loss before the actual breach on the due date of performance. Another incident of mitigation arises where the defendant in breach of the contract refuses to accept goods which he has agreed to buy, but the plaintiff is able to sell the goods at the same price to a third person. If the state of the market is such that the demand exceeds supply, so that the plaintiff could always find a purchaser for every article he could get from the manufacturer, he is only entitled to nominal damages. My lord, this is, my lord, directly on the point. Yeah, if I may read it again. Another instance of mitigation arises where the defendant in breach of the contract refuses to accept goods which he has agreed to buy, but the plaintiff is able to sell the goods at the same price to a third person. If the state of the market is such that the demand exceeds supply, so that the plaintiff could always find a purchaser for every article he could get from the manufacturer, he is entitled only to nominal damages from the defendant and not his loss of profit on the repudiated sale, and not on the loss of profit. My lord, in this case, my lord, loss of profit was the one that has been allowed. Since he sold the same number of articles and made the same number of fixed profits as he would have done if the defendant had duly performed his contract. Absolutely on this point.
Absolutely. Very simple. I contract to sell a car to you. You refuse to buy it. He, my brother, offers to buy it.
At a higher price.
Or same price. I sell it to him. No loss.
Absolutely.
You will be held to be in breach of contract, liability. But quantum will be nominal, 1 paisa. I will get.
This is exactly what it says.
You may, out of affection, give me more, of course.
In fact, my lord, if it is for your lordship, my lord, I shall give it free. My lord, this is 1719. I will just request your lordship to, my lord, go through it. This is exactly what my submission is. Loss which is avoided cannot be recovered.
Yes.
And this is exactly what, my lord, happened in our case. They avoided the loss and they acted reasonably in doing so. Then they cannot, my lord, claim the loss against me. No damage. There's a quotation, my lord, from, my lord, a judgment, Pagnan and Federally. My lord, I didn't cite this judgment, my lord, because it is here. Well, I have got this Pagnan versus Federally, 1969, my lord, weekly law reports. That has been quoted. When in the course of his business, the plaintiff has taken action arising out of the transaction, which action has diminished his loss, the effect in actual diminution of the loss he has suffered may be taken into account, even though there is no duty on him to write.
Correct. No windfall, no unjust enrichment.
No windfall, no unjust enrichment. My lord, these are the submissions on the mitigation of damage that I wanted to make for your lordship. My lord, then I shall move on to this 15% that has been granted. Now, my lord, your lordship will kindly come back to the award once more, keeping this in mind. আমার এই ভিড়টা না থাকাতে বড় মুশকিল হচ্ছে। আমার এই এটা কোথায় রেখেছি ভগবান জানে, খুঁজে পাচ্ছি না। Dr. Kindly give me এটা নাও। Lordship will please to come to the award once more. Page My lord, kindly come to page 103, paragraph 215, a very important paragraph. Paragraph 214, your lordship remembers section 23 of the Arbitration Act has been quoted, that state his defense. Then, my lord, para 215. Following the aforesaid legal position, this tribunal has to decide the claim of the claimant on the basis of pleadings between the parties. The respondent, in course of his argument, sought to urge, on the basis of written notes, part 4, that the claimant had not suffered any loss by way of flaring up, and they have referred to returns filed by the claimant with the Director General of Hydrocarbons. Exactly, my lord, this is a submission I made. And my lord, kindly see how it has been dealt with. That the claimant had not suffered any loss by way of flaring up, and they have referred to returns filed by the claimant with the Directorate of General Hydrocarbons, Ministry of Petroleum, Natural Gas. But in its SOD, Statement of Defense, the respondent has neither referred to nor disclosed those materials. Am I supposed to do that? This is the ground. It is well settled that facts on which there is no pleading, no evidence can be adduced. I said there is pleading. I said that you have not suffered any damage. An issue would have been raised on that. It is well settled that facts which are not, on which there is no pleading, no evidence can be adduced. Even then, my lord, next sentence, it shows from the chart produced by the respondent that there is flaring up. This tribunal is unable, for the reasons discussed above, to accept the respondent's attempt to contradict the finding of CCI that GECL had to flare up 28.40%, 48%. This is the only, my lord, foundation, only basis on which this award has been made. Of the gas produced in 2015-16, as it had no market for the same after respondent terminated the contract in July 624. This whole sentence is entirely the submission of the claimant before the CCI. That's all. There is nothing absolute, nothing else, my lord, in support of this. Then, my lord, the respondent has also relied on the judgment of the Supreme Court in the case of Kailashnath Associates. I will place it before lordship now. In that judgment, the learned judges of the Supreme Court held in paragraph 33 that section 74 of the contract is sandwiched between section 73 and 75, which deals with compensation for loss or loss of damage for breach of contract, which a party may sustain through non-fulfillment of the contract, after such party rightfully rescind the contract. the court held compensation is payable for breach of contract under Section 74 only where damages or loss is caused by the breach. Relying on the aforesaid observation, the learned counsel of the respondent urged that in this case, claimant has not suffered any loss or damage. These submissions have been of mine have been recorded. And see, my lord, how it has been the cursory way it has been dealt with. But such contention is clearly contradicted by the factual finding of CCI that GECL had to clear up 28.47%. What can I do? This is what has been held for the gas produced in 2015-16, as it had no market for the same. Therefore, the principles reiterated in Kailashnath have been satisfied. Then, my lord, we come to the quantum of damages. Kindly come to page 2, paragraph 217. This 28.48, this bogey has been repeated over and over again. Not at one place, 3-4 places. Then, my lord, paragraph 217. The next question is what will be the quantum of damages which can be awarded by the tribunal? In paragraph 48 of the SOC, the claimant has claimed towards MGO 6,98,363.19 and rupees 61 lakhs 7,922.28. If one adds these two amounts, it comes to rupees 68 lakhs 6,285.47. If from that we deduct the balance 63,237.52, which is available as shown in paragraph 48, then it comes to rupees 67 lakhs 43,047. Which, if with that we add the amount pleaded in paragraph 52 for MGO invoices raised from October 1 to 2014 for the sum of rupees 3 crores 93 lakhs 83,240.40 and the other MGO invoice raised by the claimant for the quarter October 2014 to December 2014 for the sum of rupees 4 crores 58 lakhs as pleaded in paragraph 52 of SOC, then in total it comes to rupees 9 crores 19 lakhs 90,288.35. Then the amount pleaded in paragraph 53 of the SOC. This is important. The MGO quantity for the invoices commencing from 1st January 2015 till the tenure of the agreement dated April 30, 2034. The amount comes to rupees 396 crores 43 lakhs 22,880.80. If all these figures pleaded in paragraph 48, 52 and 53 are added, then it comes to rupees 405 crores 63 lakhs 13,168. This calculation has been made by the claimant on the basis of 70 days in a cycle, but this tribunal has not accepted that claim of the claimant, but held that the cycle is for 75 days instead of 78 days. Considering the same, the claim is reduced to rupees 390 crores 3 lakhs 1,123. Now, this tribunal has had discretion in the matter of awarding damages. Now, my lord, we come to the quantification of damage. In exercising its discretion, the tribunal has to follow the guidance from the decided precedents of the highest courts. Thus, this tribunal accepts the standard form of damages awarded by Supreme Court. Thus, this tribunal accepts the standard form. There is no standard form of damages awarded by the Supreme Court in two of its decisions. First is Salamatullah versus Andhra Pradesh, 1997, volume 3 SCC 590. I shall place it before Lordship. And then A.T. Brijpal Singh, very well-known judgment, 1984, 4 Supreme Court cases. Following the same principle in both judgments, 15% of the amount claimed as damages has been assessed as standard, which has been followed by the courts. Following these principles, the tribunal also allows 15% of the amount of rupees 390 crores 3 lakhs 1,023 and which comes to rupees 58 lakhs 50,000 58 crores 50 lakhs 48,168. The round figure is 58 crores 50 lakhs 45,169. The above amount considered in the previous paragraph is a reasonable assessment of damage by this tribunal on the value of the balance price of MGO, which the claimant could not receive by reason of the illegal termination of the contract by the respondent. Applying broadly the principle of Brijpal Singh, this quantum of damage is decided. This principle of Brijpal Singh has been approved in the MSK projects versus State of Rajasthan 2011-10 Supreme Court cases 573. Even though the claimant has claimed interest at the rate of 15%, 15% has never been 7%. So this is the quantification of damage. 15% on the total quantity of MGO up to 2034. This is what has been said. This is what I am questioning. My lord, I will submit to your lordship, my lord, in this connection, kindly come straight away to Bharat Coking Coal versus LK Hauja. 2004-5 Supreme Court cases 109. You.
এই দেখো না সাইট করেছেন লেখা আছে আমাদের নোটে
On another aspect, I have shown. Well, on another aspect, I have cited. Please,
হ্যাঁ
copy. Well, I had placed this judgment, my lord, paragraph 11, I think. I placed it before your lordship. Yes, paragraph 11. I showed to your lordship. And I shall place, my lord, some other paragraph to in this connection. Para 11 is, there are limitations upon the scope of interference awards passed by an arbitrator. Your lordship has seen that. And then, my lord, it says, when the arbitrator has applied his mind to the pleadings, the evidence adduced before him, and the terms of the contract. There is no scope for the court to reappraise the matter as if this were an appeal, and even if two views are possible, the view taken by the arbitrator would prevail. So, my lord, one has to, the arbitrators will have to apply their mind on the pleadings, the evidence adduced, and the terms of the contract. My submission is, in the facts of the case, neither the pleadings nor the evidence adduced had been taken care of. And, my lord, so far the terms of the contract is concerned, they have relied wholly upon this. Now, my lord, kindly take, my lord, the two other paragraphs of this judgment, which are very important, paragraph 23 and 24. This is with regard to the quantification of damage. Claim 8 had been rejected by the arbitrator. Now we proceed to consider claim 9 for loss arising out of the turnover due to prolongation of the work. The claim made under this head is in a sum of ₹10 lakhs. The arbitrator rightly held that on account of escalation in wages and prices of materials, compensation was obtained. Oh, sorry, I'm sorry.
তাকে দেখতে পাচ্ছ Mr. Mitra, just to assess our thing, roughly how long it'll take?
In fact, I would submit to your lordship that by 1 o'clock, your lordship should, for the day, my lord, your lordship should excuse me.
We will not be concluding today.
No, I will not be able to conclude. There are some judgments I will.
No, that's all right. Why we are asking at 12:45 we had fixed a matter. Where is Mr. Ghosh? Devnath Ghosh? বুঝি না. Then we'll stop here today, Mr. Mitra.
Just let me place
Yes,
these two
very-
paragraphs of,
yes.
so that I don't have to trouble your lordship with this judgment again.
Yes, yes.
In the meantime, Mr. Devnath Ghosh should come. Hey, Dako, ডেকে পাঠাও। দেবনাথ কোথায়? 12:45 কি মামলা ফিক্স হয়েছিল? Well, kindly come to Your Lordship, I was placing para 23. I just placed 23 and 24, and for the day I stopped. Claim number 8 had been rejected by the arbitrator. Now we proceed to consider claim 9 for loss arising out of turnover due to prolongation of the work. The claim made under this head is in sum of rupees 10 lakhs. The arbitrator rightly held that on account of escalation in wage and prices of materials, compensation was obtained. And therefore, there is not much justification in asking for compensation for loss of profits on account of the prolongation of the work. However, he comes to the conclusion that a sum of rupees 6 lakhs would be appropriate to compensation in matter of this nature being 15% of the total profit over the amount that has been agreed to be paid. While a sum of rupees 12 lakhs would be the appropriate entitlement, he held that a sum of rupees 6 lakhs would be appropriate. 6 lakhs is though. Yes. He also awarded interest on the amounts of payable on 15%. Here, it kindly comes to para 24. Here, when the claim for escalation of wage bills and price for materials, compensation has been paid, and compensation for delay in the payment of the amount payable under the contract or for other extra work is to be paid in addition, 15% of the total profit would be computed under the heading loss of profit. It is not unusual for the contractors to claim loss of profit arising out of diminution in turnover on account of delay in the matter of completion of work. What he should establish, kindly note this, what he should establish in such a situation is that he received the amount due under the contract, that had he received the amount due under the contract, he could have utilized the same for some other business in which he could have earned profit. Unless such a plea is raised and established, claim for loss of profits could not have been granted. In this case, no such material is available on record. In the absence of any evidence, the arbitrator could not have awarded the same. This aspect was very well settled in Sandley versus Cunard White Star by the Court of Appeal in England. Therefore, we have no hesitation in deleting some of it, so and so from the claim. So, my lord, kindly note this, that only because you claim at the rate of 15%, it is not to be granted. Unless you establish in a situation like that, that had he received the amount due under the contract, he could have utilized for some other purpose. My lord, I will submit to your lordship, put it this way, that if a person is claiming damage for, my lord, wrongful termination of the contract prematurely, then he will have to show that he suffered loss because he could not have, my lord, obtained any other employment during this period, subsisting period. For 25 years, my lord, just like that, if this is not windfall, I don't know what is.
We'll just keep the matter at the same position,
You
number
got it.
1, next Wednesday. Sorry.
Next
এটা কি এটা তো কমার্শিয়াল নয় আপনার তো হয়ে যাবে
Commercial, Mirror. This is commercial.
অরিজিনাল সাইড ও
Original side commercial. Mirror.
দেন মানডে
Monday is your order.
অ্যাপ্লিকেশনের পর রেখো নিউ অ্যাপ্লিকেশনের পর ফার্স্ট হিয়ারিং ম্যাটার আফটার দ্য নিউ অ্যাপ্লিকেশনস Mr. Mitro, learned senior counsel representing the appellant, resumes his argument but does not conclude. Paragraph lists the matter once again on Shombad Dieda, retaining its position.
নিয়ে গিয়ে গুছিয়ে রাখো, হারিয়ে না যায়। মানে এটাকে ভেরি ইম্পর্টেন্ট। আবার তেমন লেখা নেই। শোনো, আমাদের পেমেন্টটা প্লিজ যেন আমাদের হচ্ছে না কিছু করে। I will not appear in. I will just not.
This is my appeal. Well, land in Polta, Bengal, NML was the company. In that company, I have infused funds.
What happened? We had
Miller,
sent
that receiver was directed to file a report, the official liquidator.
The official
And
liquidator
on-
also intends to file a report separately. In addition to the surveyor.
আমায় দিয়েছে already?
We are unable to.
এটাই দিচ্ছে, ওই দিচ্ছে।
Hmm? Have you দেখি এক কপি দিয়েছে
এইটা তো।
Surveyor.
Hmm.
You haven't had a look at this report naturally. So consider this or what?
Consider this and come back.
Yes. খোলো এই
But in earlier report also, he has mentioned the specific area, my lord, which can be handed over to them. My lord, in earlier report also,
Only issue, my lord, I am, my lord, leasehold, my lord, quarters, my lord, I am not concerned. What is concerned is the freehold land as fell from. Now, freehold land, 2014 valuation or 2020 valuation? I'll say 2014 because I'm out of pocket in 2014 fully.
we
That
think
lordship
that
will
is fair. We
consider.
think that is fair, but are you getting that quantity amount of
My lord,
land?
that quantity, my lord, in inspection, we were there, we are getting without touching anyone, my lord, we are getting. We are not touching anyone. Without touching anyone, I am getting no one is this, no one is there.
my lord, if your lordships kindly takes the earlier report, then it would be clear. In addition to this report, my lord, earlier report, my lord, page 20 and
That
page
copy দেবে?
30.
Mr. Chaudhary, let us not pass any piecemeal orders. Have you seen this report?
Yes,
How did you see this report? He doesn't have a copy. How do you have a copy?
that copy has been given by the official
দিয়ে
liquidator.
দেবেন, একটা দিয়ে দেবেন copy.
Very well, I shall have.
Give him a copy. Let him consider. And have you given him a copy of something you filed today? কি file করলো না আজকে?
কি file
Yes,
করলো?
my lord, that is the report filed by the official liquidator.
Give him a copy of that also. এই লেখো last order দিয়েছে দাও order
May I give a copy of the last?
of order.
Yes. Minutes, report চাইছে। হ্যাঁ, thank, great. এটা copy করিয়ে নেব। দুবেজি এটা।
Read order dated July 25, 2025. Paragraph. Today, a report has been filed by the surveyor, Mr. Ochin Mazumdar. এখানে রিপোর্ট থেকে বানানটা দেখে নিও। Report dated করে দেবো পরে August 7, 2025. Stop. Let the same be retained with the record. Stop. Mr. Chaudhary, learned advocate representing the official liquidator, offers to hand over a copy of the report.
300.
Acha, offers Corona has handed over a copy of the report to learned advocate for the
My lord, we are for the appellant.
appellant. Stop.
Also the copy of the report.
Paragraph.
filed by the official
The
liquidator.
official liquidator has also filed a report in the form of affidavit. No.
No, only
A report in court today. Stop. A copy of the same has also been made over to learned advocate for the appellant. Paragraph on the request of learned advocate for the appellant, to enable him to consider the aforesaid reports and, let this matter be listed again on
My lord, Monday, Tuesday, whenever lordship takes up the original. side.
Tuesday. কি একটা ফ্যাক্টটা খালি আছে দেখো তো একটা
Lordship, lordship, আমি কিছু বলছি না, শুধু 14 তারিখটা না, ওরা কিছু বলছে না।
Bengal Environmental Committee has taken out an application for an addition of party. We have served the copy of procedural of last election.
We have checked, my lord, there is no
We have to-
interference.
Deciding in the leasehold.
Yes, we are not concerned. We are on a freehold. Leasehold, we are not touching. There's a in-between road going beside it. So it's untouched, your property and mine.
ওটা পঁয়ত্রিশ কোনোদিনই ফাঁকা নিতে পারবে না। ঠিক আছে, তুমি এটা কাজ করো, এটা বেশিক্ষণ সময় লাগবে না। বুধবার, এটা কি কমার্শিয়াল না নন কমার্শিয়াল নাকি? অ্যাপেলের চাই, নন কমার্শিয়াল।
There's a demarcation.
বুধবার
Hold and freehold.
হিয়ারিং গুলোর আগে দিয়ে দাও স্পেশালি ফিক্সড করে। হিয়ারিং ধরলে তো চলবে, দিয়ে দাও স্পেশালি ফিক্সড করে। Wednesday. Wednesday.
Grateful to you.
Already.
Or whether that application will be,
Let it be listed. Give the number.
so I've already given the copies of it, was have the
দিয়ে দিও, নম্বরটাও লিস্ট করে দিও।
already listed.
But I am told they are in the leasehold property which has already been handed over by the official leader in person.
We may not entertain their application, but we can't stop them from filing an application. চলো, আর কি হবে? ডাকো যদি কেউ কিছু করে। 12:40, no. It will be especially fixed before the hearing matters.
Commercial division. Item number 2.
That I appear for the appellant. This is a section 37 appeal. Well, I'll have to start afresh before this bench.
1 second, sir.
Yes.
Yes.
Yes, sir. This is a section 37 appeal arising out
For the respondent.
of dismissal of my application under section 34 of the Arbitration Act. The award is dated 30th September 2010. The basic point that I was urging before, my lord, on the last few occasions that I argued today, my lord, I'll start afresh. But the basic point, if I may indicate, because there's not much time, my lord, I've already filed 2 notes on arguments on the heads of claim which are under challenge before, my lord. But the basic point
Did you file the 34?
The 34 was filed, my lord, in 2010 itself, my lord.
Very well.
In 2010 itself, within time, my lord. That isn't the issue, my lord. My lord, here the basic point that we have tried to canvass before, my lord, is, my lord, an award of 2010 prior to the 2015 amendment has to be viewed from a certain lens, which perhaps the learned single judge did not view it from that lens which was required to be done. An award that was passed prior to the 2015 Act coming into force was mandatorily required to comply with section 28(3) as it then was prior to amendment.
In terms of?
It was bound strictly, the learned arbitrator was bound strictly by the terms of the contract and nothing beyond. He could not have gone into usage, he could not have gone into whether it is an equitable relief that could be granted in favor of the contractor. The basic facts of my case, my lord, are I am the West Bengal Housing Board. I had floated a tender pursuant to which the contractor, that is the respondent award holder, my lord, emerged as a successful bidder. In that contract, my lord, they were to carry out, my lord, certain construction work, essentially for boring piles in respect of a construction development that was being conducted by the West Bengal Housing Board. There, my lord, it is an admitted fact. I'll take, my lord, through the award again. It is an admitted fact today that there were incorrect placement of piles made by the respondent contractor. The contractor makes such incorrect placement of piles, which is his only job under the formal work order. He makes incorrect placement of piles. Thereafter, we inform him that these piles are incorrectly placed, both in terms of position as well as the angle at which it is supposed to be placed. The contractor thereafter installs corrective piles. That is the term used by both the learned arbitrator as well as under the contract. Corrective piles are installed by the contractor. Thereafter, the contractor, while raising the final bill, surprisingly raises the bill on the corrective piles as well. The terms of the contract clearly stipulate that when you take measures for correction of a defect in the pile, you are not entitled to payment on that account. The contractor thereafter also raises claims on account of alleged additional work that has been done by the contractor for extra boring, for extra concreting work that was done. These are all additional works which are not payable under the contract because this is a fixed rate contract. There's a schedule of rates that's provided. It is provided that if any excess or other extra boring is to be conducted by the contractor, no extra payment will be released in that account. And this is the express terms of the contract, which was never challenged. The statement of claim, if I take my lord to, it's a simplicity claim on account of money. There is no challenge to any terms of the contract between the parties. Now, my short case, my lord, is once a contractor goes before the arbitrator, not having challenged the terms of the contract and being bound by the terms of the contract, cannot get any claim or additional payment, deholds the terms of the contract. And the arbitrator has gone wrong in our humble submission, my lord, by awarding claims which are deholds ex facie contrary to the terms of the contract. On that ground, my lord, several claims, there were several heads of claim made. Not all of them were allowed. In essence, my lord, a few of them have been allowed, and I've filed my notes on arguments dealing with the heads of claim which have been allowed. Only that. The learned judge, while discussing the award, my lord, takes into account not the fact that the contract provisions were contrary to the award. The learned judge goes on the point that there was sufficient evidence before the arbitrator to award such claims. This, in my humble submission, my lord, the learned judge has gone wrong, because regardless of how much evidence, I am not disputing that work has been done by the contractor. I am saying I am not entitled, or rather, I am not liable to make payment for those works if they are contrary to the terms of the contract, regardless of however much evidence is before the arbitrator. This is where, my lord, perhaps the learned judge has gone wrong. And the learned judge, on a fundamental point of law, my lord, perhaps has looked at the award from a different angle as compared to what she should have, perhaps, in a pre-2015 amendment award. And on that account, my lord, on the last occasion, my Lord Justice Banerjee had asked me to cite a decision regarding to whether, despite pendency of the section 34, when the 2015 Act comes in, whether the pre-2015 Act will still apply. On that ground, BCCI Kochi Crickets, I am
Yes,
citing.
now in another matter, we have seen that.
Yes, my lord. That is a settled proposition of law. I don't believe there will be any dispute. Here, my lord, not only initiation of arbitration, not only initiation of arbitration, award pass, section 34 file, all prior to 2015 Act. So, my lord, may I quickly, my lord, will kindly have my notes once. I don't want to, my lord, take too much time. Prothom notes. Lord, very quickly, my lord, I'll just place the portions of the award are quoted in the notes itself. I've highlighted, I've tried to the best of my ability, my lord, underline the portions of the award which in my, or rather in our submission, my lord, are contrary to law. Therefore, contrary to public policy and liable to be set aside. My lord, will kindly take my notes, my lord. The first claim, if I may start with, the impugned order, my lord, I'll take to, my lord, last. First, my lord, on the award.
Yes.
My lord, claim 1, may I start with? Claim 1, my lord, will take para 6 of my notes.
Yes.
Very briefly, my lord, I'll just recapitulate. My lord, claim 1 relates to payment for piles which were installed by the respondent as a corrective measure. Now here, my lord, we'll see the award, my lord, the impugned portion of the award I've quoted, my lord. Specifically, my lord, will kindly turn over the page. My lord, will kindly see the underlined portion. In the item rate contract with the employer's regular supervision as per applicable usage of construction work, prior to any reinforced concrete work approval and measurement of location, and reinforcement is again reinforcement and its lowering is again necessary. After approval of the respondent, the claimant completed the work. This is all a finding of the learned arbitrator on the basis of usage, my lord, will kindly note. Then at some point of time prior to 8/1/2004, prior to issuing letter marked R96, my lord, I'll take, my lord, to R96, that's at page 538, my lord, can kindly have a note. Page 538 is this document. In the documentary evidence, with pile heads popping up in the ground, discrepancy in pile geometry according to the drawing and according to ground reality in literal sense became probably prominent in some cases, leading to rechecking of the pile positions with reference to cardinal points in those cases. As a result, my lord, will kindly have a note of these words. As a result, pile numbers 1604 to 1622 were installed as a corrective measure, but the respondent at no point of time put blame on the claimant for this wrongful approval of 17 locations. Thereafter, my lord, it discusses RA bills which were raised. My clients had made ad hoc payments pursuant to those RA bills raised. But my cardinal point here, my lord, will kindly see the arbitrator has come to a finding that there is a corrective pile placement and that there is defective piles on account of which pile number 604 to 622 were placed as a corrective measure. Now, the provision of the contract Thereafter, my lord, the rest of the award, for the time being, my lord, skipping. I've quoted the relevant portion, my lord. My lord, the relevant provision of contract now is at page 88 at volume 1. If my lord kindly has a look. Page 88. So, my lord, from the award, it is evident that defective piles is an admitted position, and the fact that these impugned piles for which the volume 1, page 88.
So 18 piles per replacement piles.
Replacement piles. This was the subject matter of this claim. Claim 1 was only in respect of these piles. Only in respect of these piles. Volume 1, page 88. Muller will see the clause. I'm sorry. Muller will see the clause that starts with defective piles. That's the heading. This is a part of the contract between the parties. There's no dispute in that regard. Muller, may I just place this very quickly? Defective piles. If the tilt and shift are more than permissible limit, the concrete is of poor quality, the load test is unsatisfactory, or there is any defect which in the opinion of the engineer in charge will affect the strength of the pile will be rejected, and the following or other corrective methods approved by the engineer in charge shall be adopted for the pile in question. Muller will kindly note at the contractor's expense. Thereafter, my lord, will kindly take after the two Roman numeral clauses, my lord, the unnumbered clause at the bottom. Against all these, the contractor will not be eligible for any extra payment. It sets out, the contract sets out when a rejection can be made. It is an admitted fact that here a rejection was made. It is an admitted fact that corrective piles were installed.
So you are saying it's immaterial whether or not the respondent was responsible for the defect, because the clause says if any defect is found.
If any defect, and here, my lord, respondent has to be responsible. He's the contractor.
No, but
Nobody
the
else would.
arbitrator has probably observed that you have not made the responsible contractor responsible for the defective.
So that perhaps itself is a wrong finding.
No, that is a different thing. But
Yes, my lord. No, my lord will kindly appreciate. Here, my lord, the arbitrator holds in the part of the award that's quoted, the arbitrator holds that we inform, my lord, I refer to the letter of 8th January 2004, which is page 3 of my notes, my lord. 8 January 2004, prior to issuance of so-and-so, evidence that the pile heads popping up in the ground, discrepancy in the pile cap geometry according to drawing, according to ground reality in literal sense, became probably prominent in some cases, leading to rechecking of the pile positions with reference to so-and-so. As a result, pile numbers 1604 to 1622 were installed as a corrective measure. Well, as soon as the arbitrator comes to this finding that this was installed as a corrective measure and there were defects in piles, well, it has to be that the placement of the piles was found to be incorrect by me.
And the placement was the obligation of the contractor.
And Malad, this page 538, which I just referred to.
Contractor was probably saying that we did it as per specifications.
Exactly. Malad, that is what the arbitrator goes on. The arbitrator says that as per usage, Malad, the start of that paragraph, as per usage in this type of a contract, it is at the employer's instruction that anything is done. Essentially, that is what the arbitrator is saying. In this case, as per usage, it was the respondent who had directed the contractor to do XYZ. Therefore, the contractor did XYZ. I am showing ex facie a contractual clause to the contrary. Ex facie, the contractual clause says it is a responsibility. It was as per my instruction for installation of the corrective piles. It was as per my instructions, but that is as per a clause of the contract. That clause says if any corrective measures are directed to be taken at the instance of the engineer in charge, which is my client, you are responsible. I am not responsible for that expense.
We will stop today.
I'm sorry.
No, Mr. Mukherjee, the only thing is that you instruct the contractor. It's under your supervision. He was to act. You instruct the constructor to put a pile here. He does that. Later you find some defect or you say this is not the place. Will it be fair to say that the contractor should be liable because of this clause?
Here,
consider. We understand if there's a clause which is clear, We have to see the award, what the arbitrator says. We have to see that
Of course,
also.
of course, of
Let it retain its position where it is.
Only one request, my lord. Instead of Monday, could I humbly beseech, my lord, there's a part-heard matter before another division bench where I'm assisting my senior, my lord, on any other day, my lord, apart from
এটা
Monday.
কি commercial?
Commercial Thursday, I believe, my lord, commercial, after appellate side, my lord, takes up commercial original
Thursday
side.
করে দাও,
Thursday,
লিস্টে রেখে দাও,
my lord.
দেখা যাবে তারপর।
I'll try to be as brief as possible, my lord, to try and conclude as,
We are not rushing you.
no, my lord, but still, it's my obligation, my lord, to try and finish.
আগের অর্ডারটা কোথায়? দেখো, Mr. Mukhopadhyay, comma, learned counsel representing the appellant begins his argument afresh since this is a different bench. So he does not conclude paragraph. On the request of Mr. Mukhopadhyay, comma, let this matter be listed again on বৃহস্পতিবারের ডেট দিয়ে দিন, comma, retaining its position.
Obliged.
How long have you put in now in practice?
Lord, 4 years.
4 years. You are with some
Yes, ma'am. Mr. Shobhushaji Chaudhary.
with Mr. Chaudhary.
মানে একসাথে রান্না যেটা হচ্ছে একসাথে বাড়ির রান্না হলে মানে একটা লোক পারবে আমি একটা লোক পারবো মানে করতে পারি তো এটা কি আর কি হচ্ছে কাউকে একটা সিটি খাবার মিস করানো যাবে না বাবা থেকে না খাওয়া দাওয়া খরচা এমন টাকা পয়সা দিতে হচ্ছে হয়তো পুজোতে ঠিক করে তার আগে লাখ টাকা মাইনে করে দেবে ঠিক করতে হবে বলো নির্দিষ্ট কি খাওয়ায় তার মানে ভালো খাওয়ায় না আলাদা দেবো আলাদা যাবো তো ভয় তো বুঝলি আমাকে খেতে গেলে ভাইরা আছে সব অনেক আছে জায়গায় আছে তো আমাদের বাড়িতে রান্না করে দিতে পারে না আমাদের বাড়ি তাহলে ভাই তো আমি বুঝতেই পারছি সে তো পরে কথা কিন্তু আমার বিপর্যয় তো দাঁড়াবে না কোনো কথা হলো রান্না করে দিয়ে দিতে পারে না বলতে জন্য খারাপ আছে বলতে আমাদের আমাদের আমরা তো এরকম কি বল সেটা ঠিক করে বল আজ তো ঠিক মতই
Only
Number one,
May I just mention 11, item number 11. Lordship kindly makes it not today. I have some difficulty.
Eleven.
But we'll
11.
take it up next day, Miller, because Mr. Shao is with me, but he is not here today. I'm great.
11 টা লেখো। On the request of Mr. Shamunto, learned senior counsel, representing the review applicant.
Yes.
Review applicant, let this matter stand adjourned and be listed again on August 29.
I'm great.
Item number one, I am for the petitioner, my lord. I am led by Mr. Sanal, he is on late, my lord.
We have heard you all.
Mr. Sanali on late, my lord, kindly hear me, my lord. I am placing my application, my lord. My lord, petitioner's land in two petitioners. Petition number one's land in Mouja Hatibedia. And my lord, to that effect, petitioner's land was acquired by the state government for the development of the Holdia dock complex. To that effect, my lord, land user certificate was issued. Kindly have a look, my lord. My application for appropriate order, I have annexed that. On page number. Page number 45, my lord. Subsequent page, my lord. Page number 46, type copy one. My lord, this is to certify that sorry, my lord. Sorry. Page number 49, typed copy. 48 is the this is to certify that Shambhu Charan Das, petitioner number one. Son of so-and-so was the owner of CS plot number 62 at Mouja Hatibedia. And my lord, have been acquired in connection with the establishment of Holdia port in LA 1970-71.
Sir, we have heard you at length. We have recorded that. Today it was only listed for as to pass order.
Then, my lord, only to kindly hear me, the affidavit used by the state government by disclosing the circular for rehabilitation, allotment of rehabilitation. Only to that extent, my lord, kindly allow me, my lord. Not state is absent, my lord. Kindly allow me to place
Is
that.
state a party here?
Yes, my lord. Yes. State use affidavit, file affidavit, their affidavit.
Cannot provide them any, give them any right to, my lord.
On port land,
Yes.
port trust land.
Yes, my lord.
My
lord, after acquisition,
Eviction order was passed.
thereafter, Mr. Sanal is only.
Appellate authority.
We have heard you on several occasions, sir.
Affidavit of the state respondent has not been placed as yet, my lord.
Assuming the state says that the state has a rehabilitation scheme.
My lord.
How is that binding on the port trust?
State is party, state is responsible to allot the rehabilitation plan.
That cannot
Give. What the status saying?
State is disputing that petitioner are not entitled to get benefit of that circular. As because, my lord,
Which circular issued by whom?
Issued by the state government, my lord, for rehabilitation plot. Kindly have a look. Their affidavit. They have filed that.
দেখো ভাই কি কোথায় স্টেটের
Affidavit filed by, my lord, state respondent.
এবার করে দাও, উনি দেবেন।
Yes.
Where is the affidavit?
State affidavit.
সুভাষিস বন্দ্যোপাধ্যায় ব্যাকটিকটা দেখবেন।
সুভাষিস বন্দ্যোপাধ্যায় care of
সুভাষিস বন্দ্যোপাধ্যায়।
List.
Well, I relied upon a list in my
The court says that we are not responsible for this list. We don't know anything about that.
list. They can't say that I will also show. Just mere saying won't do. They are bound by their own documents. This is first. Second, state has come up with an scheme.
Is the state party here?
State is a party. State used an affidavit.
The document is neither stamped nor
When you were let Mr. Shannon argue first,
let it continue.
My lord, I annexed one list. They say we are not concerned with the list in supplement. Now, your lordships, I will take your lordships to the list. First, your lordships, some of the pages. I just give your lordships. Your losses kindly come to page 13. 13 of the supplementary affidavit. Out of তুমি মিলালে না তো বললাম বললে হবে one paragraph list concern. Well, I will just take your lordships. This paragraph 13, if it would be better for your lordships if your lordships look at it from the bottom of it. After page 1-3.
Supplementary affidavit annexure.
The list, your lordships, we have annexed. But from the bottom, if your lordships go up, your lordships, 13 column. What I am showing from here, my land was also on Hathiberia Mauja. This is Hathibere. My lord, Lele case 470 by 71. So this is my lord shows that there was a Lele case 470 by 71. Serial number 513. Ahollabala Pike.
Yes.
Kindly come to the middle portion, Hathibere Mauja. This is Mauja.
Yes.
And then my lord, LA case number 470 by 71.
Yes.
I was also included in this LA case. I will show that document.
Yes.
And then compensation, and then my lord, this is the list of the evictees.
Yes.
Now, this your lordships will find also from the my lord, very next page.
You are Aholla.
No, I'm not Aholla. My lord, I am your lordships. I give your lordships my name. Shambhucharan Das and Shambhucharan Patro.
How Aholla helps you?
Aholla helps. My lord, I'm
LA case.
my lord, AFM exactly. LA case.
How it helps you?
My lord, my certificate of land loser, I will show that's the same LA case. But what they have chosen, they have given these sort of persons the benefit.
Benefit of what?
Benefit of allotment of land. When my land has been taken, they have given some of them who are chosen, some of them not.
Where?
Well, this is the list.
Where this person has been rehabilitated. In whose land?
Well, they are from their land and then you lost. This is the LA case. From their land, they have been evicted.
I couldn't follow. Your land was active. You got compensation. Now, under the Public Premises Eviction Act, you have been evicted.
Malad, sorry, kindly do not, Malad. That's the different proceedings. I tell you, Lord.
Different proceedings.
That's not the same land. Land is also not the same. I tell you, Lord.
Now, you tell me this person where this whole law was rehabilitated where?
I give you, Lord, this one.
Where? In whose land?
Land of them. State provided the land.
State provided the land. How this port is then?
Oh, my lord. Acquiring body and requiring body.
Acquiring body and requiring body is under the obligation to pay compensation.
Not only that, one is depends upon the scheme. It may be employment, compensation, and land when a homestead land is taken.
Where is the obligation upon the port under which scheme that they will give you compensation?
No, I'm trying to show you, Lordship, first that this is the list from which they have given the land also.
Oh, no, this is only seen the list of persons who receive compensation. That's all.
Malad, your
But
losses.
from we get that where all has been rehabilitated,
Malad,
where he has
then
been
Malad,
rehabilitated, how much is there?
kindly come to page.
For us to compare your case with Aholla.
Malad, kindly come to Malad.
This-
I've
this
given
shows
one
that-
example. I'm coming to page 54 of this affidavit. এটা ওই পেজটা কোথায় গেল যে দাগটা নিতে পরে বলছে জাস্ট মানে জাস্ট কামিং 51 মানে I'm sorry মানে can come to page 51 first খুঁজে পেলি না লিস্টে দেখ মানে this was শ্রী অমূল্য ঘোড়াই নরেন্দ্র ঘোড়াই such and such issued by পুনর্বাসন আধিকারিক এত দ্বারা আপনাকে জানাতে যাইতেছে যে বিভাগীয় কানুঙ্গ কর্তৃক আপনাকে পুনর্বাসন কলোনিতে যে প্লট নির্দিষ্ট করা হয়েছে তাহা চূড়ান্ত তালিকা প্রস্তুত স্থাপক পাকাপাকি দখলযোগ্য নয় আপনাকে নিবন্ধিতকৃত বন্টননামা দেওয়া না পর্যন্ত উক্ত প্লটে আপনি গৃহ নির্মাণ করিবেন না এ সম্পর্কে আরো জানানো যাইছে যে পুনর্বাসন কলোনিতে গৃহ নির্মাণ করিবার পূর্বে তাহার প্ল্যান জেলা শাসক কর্তৃক মঞ্জুর করাইয়া লইতে হইবে চূড়ান্ত বন্টননামা প্রস্তুত হইবার পূর্বে আপনার গৃহ নির্মাণ কাজ তদারকি করার জন্য ইচ্ছা করলে আপনার গৃহের প্ল্যান দেখিয়া করিয়া বাধিত করিবে
My junior is here. May I come back for a moment from 33, my lord?
Now your losses left hand side. Kindly see this is the stamp of Holdia Dock and the other authorities.
Sir, Sanal, why under what scheme? Isolated letter. This shows nothing.
Well, that's
What's the scheme? Why from your right hand?
well, kindly come to affidavit of the state.
Because it's quite unusual. What you are arguing is quite unusual. You will give me compensation as well as give
Exactly. Both has to be given in
course.
homestead of land.
Only that is the only thing. Show us the scheme, show us your right, and we will enforce it.
Malad, kindly come to page 14 of the state affidavit. Affirmed by Shamol Kumar Paul, advocate on record Subhashish Bandopadhyay.
এই দেখুন তো দেখো এই ব্যাকশিট দেখো সুভাষিস বন্দ্যোপাধ্যায়
এটা কত এনেছে
Yes.
পেজ
14.
X1.
This is Malad. We have been given also photocopies. X1.
টাইপ কপিও আছে
I think type copy is also there, but I think this is legible. Probably your lordships can read it.
টাইপ কপিও দেয়া
I placed it on the last occasion. Page 16 is the relevant portion. Rehabilitation.
Page 16.
1-6.
Clause
4.
Let us start from the beginning. Page 14. Let us
Yes,
understand.
certainly, your lordships. The government have been seriously concerned about the lack of uniformity in approach in regard to acquisition of land for projects and alleviation of the difficulties faced by the dispossessed persons. After careful consideration of the matter in all its implications, government have decided as follows. Number 2, land acquisition. While land acquisition becomes inevitable, the selection of site should be done by a committee consisting of, among others, also of a representative of the state government. After deciding the district in which the project is to be located, the committee should indicate to the district administration the extent of land required and also to the basic infrastructural requirements for suggesting various alternatives in the district. The sites suggested by the district administration may be inspected by the committee before the final selection is made. While selecting the site, every effort should be made to avoid acquisition of valuable agricultural land, especially wetland, forest, or ecologically fragile land. The acquisition of whole villages should also be avoided as far as possible. The prime aim should be to cause the least amount of disturbance to human habitation, their way of life, with a view to avoiding acquisition of land for in excess of the requirements. The project authorities in the detailed project report should clearly indicate the minimum quantum of land required for setting up the unit, along with the detailed justification, functional distribution, and such requirements should be supported with a map duly authenticated by the state governments and their willingness to acquire land for the purpose. The requirement of land for expansion in the foreseeable time horizon should be taken into consideration. Out at the best, such additional requirement could be only 25% of the land required in the initial project. The public investment of and gave its recommendations on the extent of land which it considers to be justified for the project. Many of the existing public undertakings have in their possession lands far in excess of their present requirements and also possible expansion in the near future. A survey may be undertaken by the administrative ministries, departments, undertakings to identify such surplus lands. These surveys should be completed by September 30th, 1986. After identification of the surplus land, should be transferred for the appropriate use by the central government departments or for the location of ancillary units. Such establishment of the public sector undertakings or for location of the ancillary units, such land could even be considered for transfer to the state governments for setting up small industrial units for industrial access. In appropriate cases, the surplus land could be released for afforestation. Wherever feasible, construct.
It has to be a policy decision. You get a policy guideline.
Yes, Your Lordship,
There has to
then
be a specific rehabilitation scheme in relation to this.
this is the scheme, Your Lordship.
No, no.
Under
This is a policy, general policy. This is a general policy.
Then Your Lordships kindly see their affidavit. Type copy আছে তো? না।
এই তো এখান থেকে স্টার্ট তাদের এফিডেভিট এখানে বলছে প্যারাগ্রাফ এখানে ফাইলে তো বলছে যে আমাকে দিয়েছে আমাকে নেই তাহলে কেন দিল
Kindly have a look at page 4 small b. Page 4 small b of this affidavit. Paragraph small b. They are saying that they have given me allotment.
Page 4.
Page 4 small b. After, as per verification of rehabilitation allotment register, verification report, it is found a rehabilitation plot measuring such and such acre decimal in favor of Shambhucharan Das, petition number 1, son of Ananta Das, was recommended by the chairman, Rehabilitation Advisory Committee Holdia, in its meeting dated 18th August 2010 for eviction due to acquisition of land in Mauja Radhavallabh Chowk involved in LA case number 721/2002. Malad, this is this part that my land,
Therefore,
but no land acquired in LA case number 971/72 for Mauja Chakratayan jail number 3rd. This is their case. They have first allotted plot. I will show you, Lordships, that this LA case is wrong. I have been, my land has been taken in respect of another LA case.
rehabilitation plot measuring acre.
আমার ল্যান্ডই ছিল না এই শিওগুলো দেখো
LAKC 7 of 2001.
First, Lordship, 4
Page 5, subparagraph D.
person having no title on the homestead land should not be accommodated.
Where? No. Subparagraph D.
D. Yes. Next page 5.
Page 5, the
D.
therefore no land.
From Shambhucharan Das in LA case number such and such. Malad, I have said on affidavit I was not in this LA case.
And as such, recommendation of rehabilitation doesn't
So
help.
rehabilitation was there. Now my LA case is different LA case.
LA case, Moja and such.
Petition number 1 relating to petition number 2.
They have, my lord, probably misguided themselves because the name of the two petitioners is the same except, my lord, surname. This is the LA case of the petitioner number 2. So, my lord, rehabilitation scheme was there.
Yeah, please don't forget this is a review application.
My lord, your lordship has, all that I'm saying, your lordship has rejected, I could not show any scheme. So this is now scheme.
Now you have shown us.
That's your lordship.
Allow us to dictate the order then. Or is anything else you want to show us? Show. Please don't read out the entire affidavit. Show us any other document.
Then your lordship kindly see paragraph C, page 4. Following are the government guidelines for allotment of rehabilitation plot. So this is not the mayor scheme, my lord. This is the guidelines they say, and they have followed it.
Mr. In the writ petition, there was no specific prayer against the government. It was directed against the port trust. Today, you are going against the government in a review petition. Review of an appellate order arising out of that writ petition. Go, if the government has a scheme, go after the government.
But after your lordship's order, how can I go unless your lordships keep it open for me? Certainly, I will go. That I want. Government was a party.
That is already granted by Justice Basu in his revision application. When they say, kindly see that is there.
Okay.
Kindly see read the order of Justice Basu.
Correct.
In my application,
Civil division.
no, that's the lordship's, my lord, in respect of eviction proceedings. That's different.
The eviction process, you took a point that there is a rehabilitation scheme. You said that if there is a scheme, you can avail the benefit. Now, if the benefit of any state scheme is not given to you, then you need to initiate a separate proceedings.
That's your, my lord, your lordship's kindly your lordship
We are
division bench
just-
order. Your lord, and kindly your lordships, my lord, the state was a party to my writ petition.
Page 23.
You are for the port trust.
I'm for the port trust.
We'll just dispose of the review, saying that there's no ground for review. They say that the state government has a scheme for rehabilitation. If they are entitled to the benefit of, they can proceed approach the state government.
If against the state government, I've got
No, my lord, I tell us not only state government. My lord, ultimately land has been taken by the
Maybe,
Kolkata
but
Port Trust.
we are not
he doesn't
satisfied.
have any
We are
claim
not
against my client.
satisfied
Why I say this?
that port trust has any obligation, has any rehabilitation scheme. So the best we can do, we have told you, Mr. Sanyal. Otherwise, even that we will not do.
They are squatting on not my land. I have got an eviction order against them. I could not evict. Still now, Lord, they are squatting. I was compelled to, Lord, withhold their, Lord, the gratuity.
No, for
As against that, Lord, they have already filed a writ petition.
not gratuity, entire pension have been withheld.
Yes,
Entire
because they are
pension have been
squatting on, Lord, a public land.
The memo টা কোথায়? Where is the memo?
এটা তো বলছি কিন্তু তুই রিলিফ কেসটা
Number 8, 23.
Malad, the estate officer was malad, not the estate officer. The state was a party to my writ petition.
Correct, but the prayers were directed against the port trust. We just looked at the prayers.
I was a requisitioning authority,
Hmm.
Lord. The government took the property, Lord, on their terms and had handed it over to me. I have got no obligation, Lord, to give it to the land losers. The very purpose of my requirement is gone then.
Date about 24th November.
Yes, Mr. Mukherjee.
Yes.
Now, your losses, my lord, the land loser certificate I can show to your losses I have been given by the Land Acquisition Authority for Haldia project.
Who is appearing for the state?
Mr. Soumitra Bandyopadhyay at one point of time he was appearing.
Is he still in the panel? We don't know.
I've been given the land. I've been given the land certificate, land loser certificate, and that's one of the rehabilitation officer Haldia project. So they are malad intermingled, both of them. One
exercise, they are intermingling, and this separation exercise possibly cannot be done by us in this review proceedings.
No, review, I tell you losses. My writ petition has been dismissed on the basis that I have estate officers have passed an order evicting me. That's a good order. That was not my all the prayers in the writ petition. There are other prayers in the writ petition. According to me, my lord, that's not a perfect order. Anyhow, your lordship said that I couldn't show the scheme.
What is the order of the land single judge?
That's at page, your lordships, page 83, 71 both.
Of
the application for appropriate order.
that is can 3 or what is it? Can what?
This can I just show you, lordship? Can 2.
Can 2. এই দেখো can 2টা সাহেবের 73.
73.
Seventy-three or 72 थे 71 72
71 70 operative portionটা 73 তে গিয়ে পড়ছে So, Malad, I just request your losses. Kindly, your losses has gone through, Malad, my prayer. What about my first prayer? I have suffered that order. I should be evicted. That's a different land. But I am, Malad, still there. Thousands of people are there. Public health center there. Everything is there. I'm not your losses. But what?
You got employment under the scheme only. Possibly your land was taken. That's why you given the scheme.
Malad, that's, Malad, I tell you, losses.
Superannuated and still squatting on my land.
Because your land was acquired, you are given.
No, I tell you, losses, what? This portion where I have been evicted now, this is an excess piece of land, not alone.
I am not on land. As a consequence of acquisition of your land, possibly you are given employment under the code.
Yes.
You got compensation also.
Malad, compensation minimum. Law is, Malad, right from the beginning of the Supreme Court, if it is a homestead land.
We don't know. That will depend on the
Malad,
relevance.
that's your lordship. That has to be decided.
What was the
What about my first prayer? That's my prayer in the writ petition.
Just want to see the scheme from your right emanates. Where is that scheme? Show
Malad,
the
that's
scheme.
Malad, the
You think
state.
that there is a scheme.
Malad, the state affidavit.
Merely mention some schemes. Particulars of that is not.
But your lordship says, Malad, I was.
They are in the scheme. We don't know.
Now, I tell your lordship one thing.
What kind of scheme applicable to whom? Which
See, everything they should be disclosed before your lawsuits. How do I get it? Everything.
use your petition.
I have been given certificate. They say one of them have been given land.
We are only looking for a scheme that is applicable to you, that gives you an additional right.
Well, they
In addition to the compensation. Freedom. আরো মাথা খারাপ করে
Now, Malad, kindly also consider page 24 of the state affidavit. Page 24 of the state affidavit. I do not have all the documents.
You are trying to enforce your right against whom? The state or the court?
Both. Both, because this is ultimately they are the beneficiaries of my land.
Sharnal, there has to be a scheme that obliges the court.
I tell you, losses. It obviously.
If I required the property for my own use as a port, Lord, I could not, Lord, give that land back to them, Lord, as a rehabilitation scheme. Under the
I'm not, Malad, then, Malad, they have, who has given, Malad, put a question to me, myself. Who has
the
given
port
me,
has got
who
no
has given me
obligation at all.
employment? State not. Port has given me employment. The port could have said, I do not have any scheme.
That they are saying.
That's your, no. Then Malad, this is Malad, employment. Employment is also under the scheme as a land evictee. Unless there is a scheme, how could they appoint me? But I mean,
You want to see that scheme?
that's your let them that they are something counseling before the court. Something
I had to
counseling.
take an order, Lord, from the estate officer evicting him. I could not even today.
That's another aspect. You evict me today. I'm not on that.
Mr. Mukherjee, is there any scheme? We need to know it from you.
Not from my client's end, Lord. Not
Not
from my
because-
client's end.
now
I
you're-
was only the requisitionist.
That's true. Now, Malad, I have been appointed by whom?
Which obliges the port trust again to give you some.
Malad, that's
for
true.
the land.
Malad, that's
There's
true.
nothing, Lord.
That's true. Malad, I have been appointed.
In fact, they needed land from you only.
Thousands of people's land they have taken.
I don't know. Thousands of people taken. Are they rehabilitated? Where are all these?
Malad, kindly have a look 24. I can give some documents which says,
Documents are not connected.
well,
You
then
cannot
this should be
connect the
produced by
documents.
the, kindly have a look at page 24. At least in
Isolated some papers you say that yes.
Well, how do I
2021,
get
a
it,
writ
Malad?
petition is filed after, Lord, so many years. And, Lord, they are complaining about, Lord, this particular
see, this
scheme
is
not
your lawsuit.
implemented.
Kindly see, Your Lordship, in view of the fact that some problems regarding rehabilitation of the evictees due to land acquisition pertaining to Haldia Development Authority are presently experienced. Guidelines for this purpose. Page 24, Government of West Bengal Land and Land Reforms Department.
State affidavit.
Page 24 of what?
Of the state affidavit, my lord.
Koshish.
Yes. It's not that, Malad, nothing was done by the authorities. It's true that I cannot show you all the documents.
Not all the documents. Show us the applicable scheme to you. That's all.
Well, that's the basic thing. Your Lordship, kindly see, unless there is a scheme, how could this be a reply to the government, from the government?
What is it? In view of the fact that the problem regarding rehabilitation is that they're going to protect the experience, right? They have been carefully examined and said that the rehabilitation should be done against district courts and not against
Your Lordships,
evictee family.
not against the evictee family. And the minimum and maximum areas of the homestead plots to be allotted should be 2 decimals. That means 1.5 kata.
And 6 decimals.
Maximum.
And 6 decimals respectively.
And 6 decimals respectively.
It's again by the state government.
Exactly, my lord. That should, because state was, my lord, acquiring body. They were requisitioning body. That's the law.
Here after page 26.
Then kindly also consider page 26. I think, my lord, I will not place anything more. Page 26.
Whose land? Whose land? What is the obligation upon the port to give? Maybe the state government is going to play over it.
My lord, that's why the state is a party and my prayer of the repetition, prayer A.
So now what is your case? We need to know. You just can't throw a.
My lord, I take your losses, my lord, to that.
It says that the land has to be allotted. Very well, we presume that there is a scheme. That what is the obligation that the port will give you the scheme?
My lord, kindly keep my petition, read petition alive for the purpose of the state only. I will go back.
But you are on the position of the port's land.
No, that's your losses.
So unless the state allot you a land, you will not.
No. I get your losses, point. I get your losses that I'm occupying a port's land on the plea that so long I will not be allotted a plot. That's
by the state government.
That's by the state.
That is
government.
the ultimate.
That's your lawsuit for this purpose. This was hard. So that if your lawsuits can find something, give me and I will go back. I think your lawsuit, this was heard by before your law. This was matter was last heard before your lawsuit in I cannot remember exactly 2022 for this purpose only, and call for the affidavits of the state. So all that, if I'm under the law entitled, I should not be.
এই জায়গা ছেড়ে দেবো আমরা আমাদের স্টেট দিই বলছি না যে ওটার জন্য ছাড়বো না তা না।
We are granting you liberty to approach the state.
But all that is subject to your law. No, subject to your lawsuits. Not confining my kindly make alive of my right petition regard to prayer A. Prayer A cannot be. Prayer A for rehabilitation.
But we are granting you liberty. What will should you require? Dismissal of the review petition shall not preclude you from approaching the state government if there is any applicable scheme that entitles your rehabilitation. That's all.
That's the scheme.
To the state government. The state government.
I think. Yeah.
Actually, Mr. Shandal, the scheme of hope should be kept alive.
I beg your losses.
Scheme of hope.
Scheme. No, I tell you losses. Even the scheme is no longer alive. I became entitled.
Hope should be kept alive. And the litigation must continue. So we are giving you scope.
These are the high-handedness of the state.
This is a chance litigation at the belated stage. 2021, they are filing this writ petition.
লিমিটেশন পয়েন্টটা যদি
সেগুলো হবে না লিমিটেশন আবার কি
এত বছর বাদে করছে যদি
November 24.
এখানে তো অ্যাডমিট হবে না
The facts of the
শুনতে পাচ্ছি না
3 চলছে 4 আছে
কোথায়
audit.
এখনো তো কি অ্যাডভোকেট আছেন
আর কি আছে বললাম আমি যাচ্ছিলাম তাই আমার কোনো উন্নতি হয়নি আমি একটু ভালো মতো ট্রাই করতাম আরো ভালো করছি একই
A review applicant seeks to review a body control order on the grounds that
চলে যাবো
না থাকলে আবার কি করে দেবে
claimed by the state government. The petitioner has a page number rehabilitated by petitioners have the right to be rehabilitated by allotting a plot of land. By allotting a plot of land in their field. We heard Mr. Shubhir Shandal, learned advocate on several occasions, and Mr. HON'BLE Mukherjee appearing for the state, appearing for the pro-trust. We have also called for an affidavit from the state government disclosing if there is any scheme of rehabilitation as claimed by the regulator. After hearing the parties at some length, we are constrained to hold that the petitioner has failed, the review applicant has failed to produce or demonstrate any scheme from which the right of the petitioner of rehabilitation accrues. Fact remains that the petitioner's facts as noted above, facts as has been recorded in our order dated November 24, 2021, reveals that the land of the petitioner was were acquired for the port trust.
No, for the Haldia Development Authority.
For the Haldia Development Authority. against such acquisition was given compensation.
Holdia development.
And also
Holdia Port Trust.
employment.
Holdia Port Trust বলে কিছু।
Hold dog. Establishment of hold the dog.
The
Establishment of hold the dog.
we also find that while disposing the revisional application against the order of eviction, the learned judge or this court granted liberty of the petitioner to approach the appropriate authority if there is any severe wrong. That's claimed by the petitioner. That's claimed by the applicant. Next one. We are of the view that the petitioner has failed to meet the ground on which a review is warranted against the order dated November 24, 2004.
না অ্যাড্রেস করতে hold the dog অটো ঠিক আছে কিন্তু land feature
The documents relied upon by Mr. Shanda from the affidavits disclosed by the state does not really indicate any specific scheme applicable to the petitioner. Next one. If thus whether such on based on such documents, the petitioner can claim rehabilitation cannot be decided is absolutely beyond the scope of this review application. Next matter. In that view of the apostate, we are not inclined to entertain this review application and accordingly
What application? Yeah.
the dismissal of the review application, however, shall not preclude the petitioner from enforcing their right against the state.
Not against any
Lord,
authority.
kindly do not
State,
open
not
that.
be today.
Yes.
State, what is your problem?
No,
Now you
not
have
my
to-
problem. He is saying that against
No, Lord,
authority, all
can I not
authority.
make him a
That's
pro
it.
forma
He's trying to
respondent?
enlarge.
Against the state. Mr. Shandal, you will have to say something.
Trying to enlarge everything.
Against the state. Against the state.
Trying to frustrate the eviction order. That's the main purpose.
Preclude the petitioners from enforcing their rights against against the state. As against the state. Based on any application, based on any applicable scheme for rehabilitation.
Well, scheme prevailing at that point of time. Losses can
Applicable scheme, you say.
Applicable.
Applicable scheme.
Well, land was taken for Holdia Dock, Malad, not Development Authority.
Holdia Dock Complex.
Dock Complex.
Holdia doc, যেখানে Holdia Development Authority আছে,
Holdia Dock.
Grateful.
How's the next one?
Number 5.
My lord, argument has already been done. And item number 2 and 5, I am on behalf of the state respondent and others are appellant. 3 and 4.
But our last. Just for brief recapitulation, I think we had posted, no?
No, in fact, my lord,
Last order who had additional
the,
Oh,
last order.
you had filed additional written notes.
we were compelled to because, my lord, after the hearing was concluded, your lordships wanted notes. The notes which came from the state was completely contrary to what was argued.
Oh, yes, yes.
That those were not at all argued. None of those points. So, my lord, we wanted to, my lord, file a supplementary notes, my lord, dealing with that because otherwise, my lord, that would be on record. And judgments which were not referred to.
Where is the state?
I am the state, my lord. It is subject to change of two advocate general, learned advocate general.
That
At that point, the Mr. Mukherjee were argued And lastly, Mr. Dotto was filed the written notes of argument.
So what do you want to say?
Nothing.
Nothing to say. Very good.
You have given the copy of the additional letters.
Yes.
I have given,
Yes.
we have also given them.
They have given, we have.
Huh.
So Mr. Mitro, let us fix one date. It's a matter we have heard last long ago. So kindly summarize your argument and then we'll come to the hearing. All parties.
Very good.
Because we need to refresh our memory also for one day. In view of the change argument and all this also. Please inform your other side who are absent today that on that day we'll hear.
They are here, but they are the main contesting respondent.
The state. Saraswati's press we need not.
They are in a happy position.
So really the state and
The writ petition, my lord, only thing was, my lord, the writ petition while being disposed, everything was in my favor. And then it said that you initiate proceeding. Today, the whole difficulty is, my lord, even if I go and initiate a proceeding, my lord, I cannot do anything because the entire land, my lord, the state has allowed, my lord, occupiers, there are multi-storied buildings there. I cannot do anything. Portions of the land was acquired by the state in 2 lots. And this was the third one.
Yes, the third one.
Saraswati Press, my lord.
What is your fundamental argument?
My argument is, my lord, that today in the acquisition, my lord, it has been held, my lord, that the action of the state is wrongful. So, my lord, today we have to be...
Is the order of the tribunal. Tribunal's order. Tribunal's order.
Yes. In view of the tribunal's order. Now, resumption held to be invalid, my lord, and today I have to be compensated. I cannot, my lord, it cannot be said that you have nothing. I have, my lord, these are the constructions made on my land.
So you cannot take repossession of the land. You are only.
No, I cannot. State has allowed them to do this. It was in state's possession.
Before the order of the tribunal or after the order of tribunal? These constructions.
It is being there. It's being occupied by, my lord, this person's, my lord, for long.
On the basis of the third notice, third acquisition.
Yes. My lord, the first note I can recapitulate, my lord, on any day, but first note, my lord, gives everything, my lord. We have given everything on, my lord, the facts in the form of a list of, in the form of a list of dates, in the notes, my lord, everything is given, but
for one day we want to refresh our.
এটা তো পরেরটা।
Twenty-ninth, Friday.
Kindly intimate Advocate General
Yes.
if he wants to address the plaintiff, because you are the main respondent.
He has not come today.
No, that's all right. Please understand that will be the last hearing day just for recapitulation.
And not rehearing, my lord.
Not rehearing. No. No rehearing. Hey, look. List these matters once again on August 29, 2025. Stop on that date. We request learned counsel for the appellants and the state
State is also appellant, my lord, in
Oh, acha.
three
Learned
matters.
Counsel for Free India Dry Accumulators Limited and the state to briefly recapitulate the facts of the case. Stop. We intend to conclude the hearing of these matters on that date. যেটা বললাম সেটা করে দাও আমায়
Would it be at 2 p.m. or
3 p.m.
half an hour? Right at
No, 2 p.m. Sorry.
2 p.m.
2 p.m. Yes. Today also it was 2 p.m. Yes.
Yes.
Deeply approved. I will inform the advocate.
কৌশিক এই চারটে একদম টপে থাকবে, এর উপরে কিচ্ছু থাকবে না।
Deeply approved.
Six, my lord, Mr. HON'BLE is appearing for the applicant, my lord. Today, my lord, he is out of station. Praying for only wrong.
Seven.
For the respondent contempt, sorry.
I am for the petitioner, my lord. Pursuant to your lordship's order, my lord, no demolition has been considered.
Every demolition has been done.
No,
T
my
plus
lord.
one building, plastic
my lord,
seats are
nothing.
there.
But only an
plastic
eyewash.
seats are there.
My lord, only an eyewash, my
Only
lord.
plastic seats are there, no eyelog.
Still,
T
my
plus
lord,
one building, my lord.
my lord, I am showing.
Only plastic seats are there. My lord may appoint a special officer also.
My lord, the photograph is here, my lord. Your lordship can go through it.
Yes, yes. Keep the photograph.
Till date.
No, have you filed any affidavit?
No.
File an affidavit.
Nothing
saying
has been,
everything.
Nothing has been done, my lord. Only an eyewash, my lord. They went. Only as
File an
T
affidavit.
plus one building, and that also, my lord, they are not residing there.
File an
They are
affidavit.
residing there with plastic seats.
Mr. Banerjee, file an affidavit if necessary. Annex photographs to the affidavit. Esho likhe now. Learned advocate for the petitioner says that the demolition work that the Howrah Municipal Corporation was required to carry out has not been done.
Numerous times, sir.
Stop. Paragraph.
only an eyewash, my lord.
Yes,
kindly,
right.
kindly record
Numerous
that, my
times
lord.
that have
Only
been
an eyewash.
You dictate the order.
My lord,
madam.
I'm sorry.
Dictate the order.
Sorry.
Learned advocate for the corporation strongly disputes such submissions. Such submissions. Stop. He says that the entire demolition.
Led by Mr. Swarup Banerjee.
Contempt মানে কি?
Contempt. No. Applicant.
এভাবে বলো না, জিজ্ঞেস কর, দেখো কি মুশকিল।
He will. That was required to be done, comma, has been done. Paragraph let the alleged contender file an affidavit.
Extensive affidavit.
An affidavit.
Photographs.
Bringing on record whatever he has to say. Stop. If necessary, he may also, if he necessary na, if he deems it fit, comma, he may also annex photographs of the concerned site to the affidavit. Stop. Let such affidavit be filed by August 28 with advance copy to learned advocate for the petitioner.
Can it be 4 weeks?
আজকে কত তারিখ? Very well, by September 11 with advance copy to learned advocate for the petitioner. Paragraph list this matter once again on September 12. শোনো কৌশিক, 29 বেঞ্চ, তারপর 12th বেঞ্চ করবে। Grateful.
My lord, I have missed, my lord.
Which matter?
This
This
matter.
matter, he is for
My-
the,
My property is involved. Heavy monsoon season is going on.
Very well. We have called for an affidavit, nothing more we have done.
Yes. Yes, I did.
Number 8. But I am for the petition. Contempt for not complying with your lordship's order dated 20 March 20 May 2020 22. But I have served.
You have served.
Yes.
How have you served without our order?
No, copy of the. This is not contempt.
First time.
This is the first time.
Order is where?
Order, my lord, at page 28. Starts at page 28.
28.
Relevant portion. Operative director. At page 40, my lord. Page 40. We are of the opinion that justice will be served if the state is directed to pay compensation to the appellant, as has been paid to the similarly circumstanced persons whose land have been acquired and who have been paid compensation following the LA case number.
You communicated the order.
Yes, madam. I have communicated my next page. I have communicated my.
এসো সার্ভিস করতে বলে দিচ্ছি
Then my lord, I have served contempt notice at page.
Very well. You may have to change your respondent number 1.
Yes, madam.
Huh? There's a new incumbent now. The respondent number 1, whom you have added as respondent number 1, is now the chief secretary. Leave is granted to the to learned advocate on record for the petitioners to add the new incumbent in the post of secretary, Department of Land and Land Reforms, Government of West Bengal, as respondent number 4, respondent number 4. Stop. Let necessary correction be made in the cause title of the contempt petition paragraph. This contempt application has been taken out alleging willful violation of a judgment and order dated May 20, 2022, whereby we had disposed of MAT number 202 of 2022 along with the connected application. Stop. The operative portion of the said order reads as follows. A running page 40 থেকে প্যারাগ্রাফ 27, 28, 29 তিনটে সেট আউট করে দেবে কোট করে মার্ক করে দিলাম paragraph. Learned advocate for the petitioner says that in spite of due communication of the said order, the respondents have not paid compensation to the petitioners. Paragraph. Let service of this contempt petition be effected on the respondents, including the added respondent, and affidavit of service be filed in court on the next date. List the matter. Better you come back on the 12th of September because 29th August we'll be hearing only one matter. September 12th.
Our department is directed to add the new incumbent.
You do it. We are granting you leave. We have granted you leave. Add by hand. Oh, you have to find out. Do you know? In course of tomorrow, leave is granted to add the new incumbent. Oh, by Monday date, Monday. Yes. মনে পড়লো?
Number 9.
Met with the
My lords, I am for the petition.
Service?
Pursuant to your lordship's earlier direction, my lord, I have served upon the alleged contemnor by hand.
Dekhi.
May I request your lordship, my lord, to see the last annexure of the affidavit of sale. The last page, sorry.
What is Xerox copy?
My lord, this is yes, my lord. This is a receipt which is given from the municipality after serving it by hand. It is a Xerox copy, yes.
Where is the original?
Original, my lord, I do have it, my lord. I do have it in my hand. I did not annex in the affidavit of sale. It was the Xerox, my lord.
Let us see.
My lord, this is also a photocopy, actually.
What kind of thing is this? They won't give you an original receipt or an acknowledgement.
Because, my lord, I tried to, my lord, at first send by speed post. My lord, in this meantime, my lord, there has been, my lord, some difficulty in the Indian Post Service for the past 7 days. So, my lord, then I instructed my client so that he serves it by hand.
So it's a strange service.
My lord, if your lordship,
You have not served with through post.
no, I could not, my lord, because of there is difficulty, my lord, in the India Post, which was cured, my lord, day before yesterday. So, my lord, if your lordship, my lord, I'll once again serve and come back to your lordship.
Better.
As your lordship.
Do that. That will be authentic.
As your
Or
lordship.
Xerox copy.
Follow my.
From the affidavit of service filed in court today, we are not happy that the alleged contemnors have received notice of this contempt application paragraph. Let fresh service be effected and fresh affidavit of service be filed in court on the next date. Paragraph lists the matter is shop 12th September.
12th. My lord is sitting on 29th, my lord, I have heard.
But 29th we are sitting. Very well, 29th rakho kisu hobe na. Because that
Let it be, my lord, on 11th.
the big matter will be
Let it be, my lord, in that event on 12th.
29th.
No, let it be 12th.
12th September.
Grateful, my lord. Once this affidavit of service be taken on record. Grateful.
Lord, in this matter, I'm appearing for Uttara Court wrong mission. Unique.
Yes, sir.
I'm appearing for Uttara Court wrong mission.
Number 10. Pass over. Cholo.
The review of the order.
Item number 12, my lord.
Tenta? হ্যাঁ পাস ওভার হলো 11 ও 11 হয়ে গেছে 12.
Item number 12, my lord, I beg to appear for the review applicant.
Yes.
My lord, the applicant was the respondent in the appeal from which this review application arises.
Yes.
My lord, if I may, at first, my lord, give my lord the brief of the facts. My lord, what had happened?
No. What has happened will appear from the order.
Yes, my lord.
A matter for which he did not read the record because the review application has been filed beyond the period of 576 days. No application for condonation of delay has been filed.
Review application has been
Lord,
filed.
that is the report of the stamp reporter. Lord, he did not look into that.
এই ফাইল নট হিয়ার বলছে কেন গো ফাইল তো রয়েছে হ্যাঁ Which is the order under review?
My lord, it's dated 6th April 2022.
6th April 2022. ডেট পাচ্ছি না তোদের Yes, 6th April. 6th April 2022. And when have you presented the memo of review?
My lord, it is beyond time, my lord.
December 23.
December 23, my lord.
12th December 23. Hopelessly barred.
It is beyond time, my lord. My lord would kindly grant me the leave to.
Reporter reported 576 days delay.
It appears there is a delay of about 576 days in presenting this application for review against a judgment and order dated April 6, 2022, whereby several appeals, including FMA 739 of 2021, were disposed of. Paragraph on the request made by learned advocate for the review applicant, we.
My lord, may I, my lord, there is a judgment, my lord, of the Honorable Division Bench of this court that in review from a writ petition, perhaps, my lord, the limitation does not apply. My lord, I shall come back with that judgment.
We adjourn
Definitely.
this matter.
Passed in, my lord, the Andaman bench of this court by His Lordship, the Honorable Justice, the Honorable ex-Chief Justice, my lord.
Adjourn this matter and direct it to be listed once again on September 12.
I shall come back. Grateful, my lord.
Mr. Banerjee, what judgment he's talking about?
Talking about
Justice Bhaskar Bhattacharjee.
That is a judgment of Honorable Justice Samarit Banerjee presiding the division bench in writ appeal.
Justice Samarish Banerjee.
Banerjee.
Not Justice Bhaskar Bhattacharjee.
It is Bhaskar. I am referring to, my lord, the justice.
Give your learned friend the reference.
The first judgment.
Please take the citation, consider and make your submission.
Was the judgment and that was held, my lord, that in a writ appeal, no limitation will apply.
In a writ appeal,
A writ appeal.
not in review.
May I give the citation right here?
So you please go outside and give it, call the list.
Item 13,
Next.
14,
May I serve and come back, madam?
I am appealing on behalf of the respondent, private respondent, my lord. I have not served, I have not been served with the
He
copy.
says he will serve. Why are you so angry on a Friday evening? Serve and come back. Let service of this review application be effected on the respondents and affidavit of service be filed in court on the next date. Paragraph lists the order matter on September 12. Second call, Koro.
number 10,
Apurvo, usual order. 21 in review. Second call. 10, give your appearance. Oh, Baba, give your appearance, sir.
Lord, if I review, thereafter
একটু বলে দাও না ডিসমিসড হয়ে গেছে।
item 13,